କାଲି ମୁଁ 4:30 ଜାଣିଲି ଯେ ମେମୋଟା ମୋର ଆଲାଉ ହେଇନି। ମାନେ ଆମେ ଅଲସୋ ଡକୁମେଣ୍ଟ ଆଣିଛି ତାର ଫ୍ରାକ୍ଚର ହେଇଯାଇଛି ଡ୍ୟୁରିଂ ଆକ୍ସିଡେଣ୍ଟ। ସର୍ଟ ଟାଇମ୍ ଆଇ ଫାଇଲ୍ ଏକ୍ସଟେନସନ୍ ଅଫ୍ ଟାଇମ୍ ବଟ୍ ଅନରେବୁଲ କୋର୍ଟ 7 କୋର୍ଟ ନଥିବାରୁ କେସଟା ଲିଷ୍ଟ ହେଇପାରିନି।
You have been granted interim bail
ମାଇ ଲର୍ଡ
for how many months?
ମୁଁ ପାଇଥିଲି 1 month 15 days।
So
ଅର୍ଡର ଜୁଡିସିଆଲ ଅର୍ଡର
it's all right. You surrender and
ମୁଁ ଗୋଡ ଭାଙ୍ଗି ଯାଇଛି ମାଇ ଲର୍ଡ ଆକ୍ସିଡେଣ୍ଟ।
we do not know. You surrender and file a fresh bail application. Why?
ମୋତେ 7 days
extension?
ଦେଲେ ମୁଁ ଅପରେସନ କରି ମୋ
All
ଗୋଡ
right.
ଭାଙ୍ଗି ଯାଇଛି ମାଇ
It will
ଲର୍ଡ।
come in due course. We have already said fix the date. Yes.
Date of surrender ମାନେ 20
You do not know. You surrender, otherwise the consequence will follow. Yes.
Pardon to mention, my lord, criminal appeal, my lord, appellate, my lord, more than 7 years in custody.
Please give. Yes.
Pass over item number 4.
Affidavit filed by the AG prison.
Just a minute. Let us see that order. So the law secretary has already in his affidavit what are the guidelines, rules he has annexed it.
The prisons filed as per the query of my lord. Here, my lord, actually the premature release by the excellence governor, not by the state.
Where is that order?
That is not.
It is there. Annexure 2. Yes, it has to be. What is the question of appropriate? Appropriate government means it is government.
Premature because the mercy petition अनुसार governor
No, एक केस प्रकृति कौन है?
mercy petition मेरे governor.
कहीं से और
I will come to pay मतलब 12
para 10.
Page 4
Yes.
As per the recommendation of the Merchant Board, His Excellency Governor of Orissa, in exercise of the power conferred under Article 161 of the Constitution of India, has been pleased to remit the unexpired portion of the sentence passed on the appellant and order for this or his premature release. In this connection, copy of such release order communicated by law department letter dated so and so is annexed by annexure E method.
No, Mr. Das, you come to annexure 2 itself. That is the resolution of the government, the order of the court, government.
Annexure?
Annexure 2. Pursuant to the modification of paragraph 3 and 4 of the guidelines issued by the National Human Rights Commission.
That is my
Page 11.
Page 11.
the guideline for the premature release.
Status is a guideline then, 433A.
I am on the affidavit of the DG prison bank.
Right. The other one that.
Other one.
You have stated in paragraph number 10.
10.
Page number 4.
4.
Please read it once again.
May it comes to Mr. Miller, I will start from the paragraph. 7, my lord. Page 2, my lord. And it is respectfully submitted that the case of the appellant was considered on mercy, taking his terminal illness conduct into consideration.
You are reading which paragraph?
Para
7. Yes. Please read it once again.
That it is respectfully submitted that the case of the appellant was considered on mercy, taking his old age, terminal illness, conduct into consideration before completion of 14 years of imprisonment in view of the provision of Article 161 of the Constitution of India, specifically modified in last paragraph Law Department Resolution number so and so dated 25/5/2005. It is respectfully submitted that the district authority, that is Superintendent of Police Balangi and Collector and District Magistrate Balangi, had recommended the case of the appellant for premature release from jail. Copy of this was and to be that it is that it is respectfully submitted that the medical board had examined the appellant on 4/2/2012 and opined as under. Sri Lajaras Chitriya, convict number so and so, District Jail, Balangi, aged over 70 years. He is suffering from old age, sequel and locomotor disability, mental aberration, and hard of hearing. So it is quite difficult in his part to do daily activity of living. Hence, he may be released from jail to lead a near normal life without being a burden to the jail authority. Copy of the annexes C. 9. That in view of the recommendation of the district authority as well as the medical boards, the mercy board had recommended the case of 4 convicts, including the appellant, in its meeting held on 27/8/2012. That copy is annexed D. Namal Parate. That as per the recommendation of the mercy board, His Excellency, the Governor of Odisha, in exercise of power conferred under Article 161 of the Constitution of India, has been pleased to remit the unexpired portion of the sentence passed on the appellant and order for his premature release. In this condition, copy of such release order communicated by Law Department letter dated so and so 31/10/2012 is annexed. Here is annexure E. Accordingly, the appellant was released from jail, district jail Balangi on 3/11/2012. It is humbly submitted that by releasing the appellant prematurely, no condition was imposed on him to the effect that if the result of the appeal so differs, he is to be recommitted to release.
No, no condition.
No
No, so yesterday we are pointing out that there are decisions of the Honorable Supreme Court that even in a case where that stipulated period of 14 years as prescribed under 433 A CRPC has not been completed or it has not been undergone by the convict, then also the governor has power under 161 Article 161 of Constitution of India to commute the sentence, and that is how perhaps that has been allowed. And that decision, I think it is case of Manuram. Yes? Maruram versus Union of India. So, have you taken down those 2 decisions? Please take down and go through it. One is Maruram versus Union of India.
Program.
MARU.
MARU. Maruram versus Union of India, 1981, Volume 1, Supreme Court Cases 107. The other is State of Haryana versus Rajkumar, 2021, Volume 9, SCC 292. So that has been in these 2 cases, it has been stated that the governor has the power. It can be exercised even during the pendency of the appeal, and what would be the outcome. So that is why in this case, even this conviction remains. So that would be a stigma, of course, but he cannot be taken into judicial custody once again. But we'll see it, you go through it further. We'll take up this matter tomorrow. It is there in the weekly list.
Because this Maruram case is one where the violation of the provision under section 433A has been challenged and a constitution bench has.
So you just keep it on record. Okay. We'll call it tomorrow again once again.
Item 8.
I am in VC, my lord.
Yeah.
May I please your lordship? My lord, through one prisoner petition, my name has been reflected in this case, and I do not have any document, my lord.
Pramod Kumar
Pramod Kumar Nigam, my lord.
Yes. What do you say? You are from
Bhubaneswar, my lord.
Bhubaneswar. Achha. Okay. So what do you say about the bail? Do you want to move this bail application today?
No, my lord. It may be taken up some other day, my lord, because I do not have any document, my lord.
Documents means do you want then we can supply you the by way of pen drive if you provide, then the entire LCR etc will be supplied to you. There is no problem in that. If you have no paper, you say, for which you are not able to move this bail application because on the basis of prisoner's petition you have been engaged as the counsel.
My lord.
If you require this LCR, even the appeal memo, etc., it can be provided to you if you want. Desire
In
it.
soft copy, you can get it.
Can get the soft
But
copy.
the thing is that, my lord, no members of the petitioners, they are in touch with me, my lord. So let me take instruction, my lord. Then
He has
Oh, he has made a repetition from the jail.
jail. Do you know? Don't you know this man, or you have no contact with this man?
no, I do not have any contact. Once he had met me, but no family members of his this person. They never have come to my lord. That's why I have to take instruction, my lord.
Where is this person now? In
He
which
is in custody, my lord. He is in jail.
place he is in? He is in Jharpada.
Jharpada,
So you want to meet him?
my lord.
Okay. That's one thing. You meet him and you can move the bail application. We want to put a very. Do you want the trial court records for moving the bail application, or you will take that decision afterwards after meeting your client, that client, Sushil Digal?
My lord, let me take instruction, my lord. Then I will take my lord.
Okay. So then let it come on 1st of July 2024. In the meantime, you meet and take your instruction. This how he was engaged. From see the order. Achha, proceed. Now you want to. Achha, it is on the basis of the prisoner's petition. All right.
I beg your
Mr.
pardon, my lord. On the direction, lordship, I have contacted him yesterday.
No, it's all right.
Right, that can.
Mr. Pramod Kumar Nigam, alias Nag, appears through virtual mode from virtual High Court from Khurda at Bhubaneswar. Mr. Nag has been engaged as the counsel for the appellant Sushil Digal, alias Sushil, on the basis of prisoner's petition received from the prison welfare officer, Special Jail Bhubaneswar. When counsel submits that is not having any document with him and he wants to contact the appellant before moving the application for bail, and if necessary will request the court to provide the necessary documents. And he seeks for an
In soft copy.
in soft copy. And he seeks for an adjournment put of this matter on the week commencing from 1st July 2024. So it will come on 1st July 2024. Okay.
Yes, my lord. Obliged.
Item 11,
Disposed of case, yesterday lordship directed me to take instruction. I took instruction that till that the matter has not been heard, till that the appeal is pending. The hearing has not been commenced.
No, we asked you.
You already informed. He has also called me. There is coming, but he is not there.
Miss Naidu is supposed to,
He called me also at 10 o'clock that he is coming.
because he
So
the court has sought for an
Well,
extension of time, but that is of the year
Year
2021. That's why we want, and he sought for time of 4 months.
4 months. Because already that passed, man.
That is passed, but if it is still pending, we
Pending,
can
Give it time.
give
Still
time.
pending.
There's no problem.
Yesterday I
he
took
says that-
instruction from the conducting council. He told me that till that hearing has not
Just
been
a moment.
commenced.
Give a passover.
Acha, please call her
I'll
so
take
that I'm passing it. Yes.
item 13,
Item 13, arguing counsel is very in personal difficulty as his wife's health is not good. So he has not returned from his village. So
Oh,
Sapan Kumar Pal.
Sapan Kumar Pal.
My lord. So
So
he
what do you
requested
want
me to-
now? You want
Uh,
adjournment?
My lord. Only for it will good on 24.
24.
My lord.
Adjourn करियो. S.K. Pal. Mention is made on behalf of Mr. S.K. Pal for adjournment till next week.
My lord.
Put up this matter on week commencing from 24th June 2020.
Obliged.
item 18,
Last occasion, my lord, called for the CA
Please
of the
use the mic properly.
last occasion, my lord, had called for the CA of the accused.
So you have remained in custody for more than 7 years.
My lord. No, I am called on. He was on bail, my lord, during the trial, my lord.
No, the custody certificate which you produced, that shows that
More than 1 year.
Lord and Council has produced the custody which indicate that he was on bail during trial. Acha, for a period of 6 years and 5 months.
Yeah.
And after pronouncement of the judgment, he was So it's a case of double murder. Has to take instruction about the criminal antecedent. What is your instruction?
No answer.
No antecedent. So, do you want to move the bail application today?
Uh,
Are you having the deposition copies with you?
No.
Yes. So move the application. That's
my lord. Lord, no eyewitness is there, my lord.
no eyewitness.
My lord.
Okay. It's a case of double murder. Then what are the materials on the basis of which the land and
Material
trial
matter
court has convicted you?
A material matter only the informant is there, who is PW9, my lord.
We are asking you what are the circumstantial evidence on the basis of which your conviction order has been passed by the learned trial court.
No, that's only the PW9.
Are you ready in this? PW9 is not, we want that what are the circumstances like extrajudicial confession, like dying declaration, last scene. So that you are to say, not that PW9, PW1. You said that there are no eyewitnesses. It's all right. It's case based on circumstances. We want to know that what are those circumstances basing on which the learned trial court has convicted you. If you are ready, argue the matter, or you can take time and adjourn the matter any other day. There is tomorrow. All right.
Miss Naidu is on.
Pardon, Your Lordship.
Yes, Miss.
Pardon, Your Lordship. The display was showing 4, so I just went off for a.
No, it's
Your
all
Lordship
right.
had asked for instruction with regard to, and they are tracing the file, Your Lordships. They're trying to trace the file, and I've been instructed that the appeal may have been disposed of, but still to there is no documentary. I'm not able to get the date if it has been disposed of. May I please taken up next week?
Miss Naidu, the Learned Council just said on instruction that no decision has yet been taken. So,
Lordship, let the matter be taken up next week because I was just informed it has been disposed of.
there is
Next
no.
week, Your Lordships.
All right. This is item number. Huh? All right. Miss Pratyusha Naidu.
11, Your Lordships.
11.
11.
Learned Council appearing for opposite parties number so and so. The Endowment Commissioner who procuration submitted that he wants to obtain instruction as to whether first appeal number 3 of 2019 which has been directed to be disposed of by this court by June 2020 in WPC number 15951 of 2019 and by it later dated later dated 11/6/2021, Commissioner of Endowment Odisha Bhubaneswar has sought for extension of 4 months time for disposal of the said appeal is still sub judice or disposed of. Put of this matter on 24th of June. 24th will do, Miss Naidu.
Lordships, 24th will.
Okay, 24th of June 2020.
Oblige, Lordship.
Weekly list item number 1.
Yes, Mr. Sarangi, you can
Yesterday,
proceed
my
with-
lords, your lordship has seen the affair, page 18. At this moment, only two things your lordship can take note of. Two things are missing. The
in the
time
FIR.
in the affair,
Just
which subsequently has been added. I will call
okay.
appreciation part later. my lords.
Yes.
So far as the timing that
mic to adjust. Acha, just a minute. We want to see that whether those.
yes, they are there.
Oh,
ଅଛନ୍ତି ଆଜ୍ଞା
council को କହିଥିଲି present ରହିବ।
ଶୁଭୁନି
what is the name of the land and council? ଆପଣଙ୍କର ନାଁ କଣ?
Advocate Subal Gatia.
हाँ?
Sir, Subal Gatia.
ଆଚ୍ଛା ଆପଣଙ୍କୁ ପ୍ରେଜେନ୍ସ ରହିବାର ଏଇଥିପାଇଁ ଆବଶ୍ୟକ ପଡିଲା ଯେ ବର୍ତ୍ତମାନ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ହଉଛି କାଉନସିଲ ମାନେ କରିବେ ତ ଯାହା ସେ ବିଷୟରେ ଟିକେ ବୁଝେଇ ଦେବେ ଦୁଇ ଜଣ ଆପେଲାଣ୍ଟ କୁ ଆଉ ସେମାନେ ଯଦି କିଛି କହିବାକୁ ଚାହାନ୍ତି କାଉନସିଲ କୁ କେସ୍ ବିଷୟରେ ତାହେଲେ ଆପଣ ସେ କଥା ବୁଝିକିନି ମଧ୍ୟ କାଉନସିଲ କୁ କମ୍ୟୁନିକେଟ କରିପାରିବେ ସେଥିପାଇଁ ଆପଣଙ୍କର ଉପସ୍ଥିତି ଆମେ ଆଣିଛୁ ହେଲା ତ ଆପଣ ବର୍ତ୍ତମାନ ଶୁଣନ୍ତୁ ପ୍ରୋସିଡିଂ ଦେଖନ୍ତୁ ହେଲା
the two things which are missing in the affair subsequently added is the time gap that the Giridhari started first 15 to 20 minutes after the other two deceased they followed. That is not there in the affair. Secondly, so far as the witnesses 3 and 4 who are the son and daughter of deceased Savitri, that she informant along with them came out and went inside. So they witnessed the occurrence, which that is not there in the FIR. FIR only indicates the informant came out and saw the occurrence. So addition of two things have been added.
what has been added in the
First is
which was not there in the FIR.
subsequently it will come in evidence.
What
First is the time gap. All three FIR doesn't indicate that first the Giridhari went to the land. 15 to 20 minutes after these two ladies followed. So Giridhari was killed in the land. The ladies were there near the tubewell, who is the informant witnessed. But in the affair, that time gap that they went one after the other is not there.
What is there in the FIR? Let us see once again. Because that portion just you show that
5 lines, Millers.
from the top.
Yes, 5-6 lines.
Okay.
ସାବିତ୍ରୀ ସାହୁ ବୟସ ସୁଆଂଶୁ ଧାନ କାଟିବା ପାଇଁ ଜମିକି ଗଲେ ଜମିକୁ ଗଲେ
ଟାଇମ ଦିଆଯାଇଛି ଦିବା 2ଟା ସମୟରେ
ଆଜ୍ଞା 3ଟା
2ଟା ନା 3ଟା ନାଇଁ
3ଟା
ଆଚ୍ଛା ହଉ 2ଟା 3ଟା ହଁ 3ଟା ଦିଆଯାଇଛି 3 ଘଣ୍ଟା ଠିକ
ଆଜ୍ଞା।
ରାଇଟ
ଧାନ କାଟିବା ପାଇଁ ଜମିକୁ ଗଲେ 1 2 3 7th ଲାଇନ ମିଲର୍ସ
ହଁ
ଜମିକୁ ଗଲେ
ହଁ କିଛି ସମୟ ପରେ
ପରେ ମୁଁ ଘରୁ ବାହାରି ଆସିଲି ଦେଖିଲି ନଳକୂଅରେ ସୋ ଏ ଯୋଉ ଜମିକି ଗଲେ there is it's not specified that one after other they left ସମସ୍ତେ ଗଲେ that is one part ତାପରେ କିଛି ସମୟ ପରେ ମୁଁ ଘରୁ ବାହାରି ଆସିଲି ଦେଖିଲି ନଳକୂଅ ପାଖରେ ମୋ ମା ଏ ଯୋଉ ମୁଁ ଆସିକି ଦେଖିଲି not that myself and the others
ଅନ୍ୟ ଆଇ ୱିଟନେସ୍
ଆଜ୍ଞା ଏ ଦିଟା it's missing in the affair and two things have been added.
ନାଇଁ just continue little further. ମୁଁ ଘରୁ ବାହାରି ଆସି ଦେଖିଲି
ନଳକୂଅରେ ମୋ ମା ପାଣି ମାରୁଥିଲେ ମୋ ନାନୀ ବୋତଲରେ ପାଣି ଭର୍ତ୍ତି କରୁଥିଲେ ହଠାତ୍ ଏଇ ସମୟରେ ମୋ ମାକୁ ତୀରବତୀ ବେହେରାଙ୍କୁ ଆମ ଲପଡା ଗ୍ରାମର ନବୀନ ଦେହୁରୀ ପିତା ସୁଆଂଶୁ ଓ ନବୀନ ଦେହୁରୀଙ୍କ ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆରେ ହାଣିଦେଲେ. That both have assaulted. This part is also diluted. ତାଙ୍କର ଚିତ୍କାର ଶୁଣି ଆମ ଦାଣ୍ଡ ବାଟରୁ ଚିତ୍କାର ଆସୁଥିବା ପଟକୁ ଅନାଇ ଦେଖିଲି ଉଭୟ ନବୀନ ଦେହୁରୀ ଓ ତାଙ୍କର ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ମୋ ବଡ ଭଉଣୀକୁ ଧାରୁଆ ଟାଙ୍ଗିଆରେ ଗୋଡାଇ ଗୋଡାଇ ହାଣିଦେଲେ ଓ କହିଲେ କିରମିରିଆକୁ ମଧ୍ୟ ବାଟରେ ହାଣି ଦେଇଛୁ। ଦ ଅଦର ଡିଜିଜ ନିକନେମ୍, ଗିରିଧାରୀର ନିକନେମ୍। ସେ ରାଗରେ କହି ରାଗରେ ଦୌଡ଼ି ଦୌଡ଼ି ଆସିଲା। ତା ପଛେ ପଛେ ତା ସ୍ତ୍ରୀ ମଧ୍ୟ ବୋତଲ ଧରି ଆସୁଥିଲା। So two parts are
What
added.
you say that from the bare reading of the FIR, it would say that at the spot this PW1 was only present, not the other two eyewitnesses.
Yes, one part. The time gap is the other part. ଜଣକ ପରେ ଜଣେ ଗଲେ. Why that has been done? If the time gap is not given, then it's highly improbable that somebody has witnessed it.
But one thing, Mr. Sarangi, jaha ethi kuha jaichi je it appears that by the time the assault on these two ladies took place,
Yes.
the assault on that Kirmiria had already taken place.
Yes, thereafter this assault. So if
just a minute. From this reading, it appears that perhaps the first assault was
already over.
already over.
Over.
କାରଣ ସେଇଥିପାଇଁ
ଆଜ୍ଞା।
ସେମାନେ କହୁଛନ୍ତି ଯେ ସେ ଯୋଉ ତା ଭଉଣୀକୁ ମାରିଲା ପରେ ସେ
ଯେ ଆମେ ମାରି ଦେଇଛୁ ତାକୁ।
ଆମେ ମାରି ଦେଇଛୁ।
ଆଜ୍ଞା।
ସେଇଥିପାଇଁ ସେଇଥିରୁ ଜଣା ପଡୁଛି ଯେ perhaps the first assault was on that male.
So that I humbly submit, my lords, unless this time gap is given, if they went together, so that it becomes highly improbable on any of the persons to witness the murder. Either the person PW5 who saw it at the field when the Giridhari was killed there, then it's an impossibility because there is a time gap. Simultaneously, it has not happened. By road, spot map, what they have indicated, by road, it's 3 kilometers. The shortcut, the walkable road, it's 800 meters.
No, suppose let us say, Mr. These three came together. Just let us say hypothetically.
These two stayed back and the other went
person
away.
went away. Okay. So this man,
Because
PW1,
overall impact, your lordship will consider. I am just pointing out.
you are
Ultimately,
trying
your
to
lordship will
whether this can be, you are finding out that this is mentioned that as if they went together, but it is the prosecution case also that they went one after another.
one after the other.
But even if it is taken into account that they went together, suppose these two
I got your lordship. That lady stayed back and the other fellow went
person
ahead.
went away. The
Yes.
assault took place there.
That is a possibility.
That is possibility also.
Yes.
Okay. So
And the second part, both of them assaulted. Subsequently, it was found
just
the other man,
please,
son, has never assaulted.
take a pause for a moment. Who are the other two eyewitnesses who
3 and
saw
4.
the occurrence?
Second occurrence.
Yes, no,
Three-
T-well occurrence.
Yes, that is the second occurrence. 3 and 4. Savitri, ପୁଅ ଆଉ ଝିଅ. They said ମାଉସୀ ସାଙ୍ଗେ ଆମେ ବାହାରକୁ ଆସିଲୁ.
This presence of PW3 and 4
Yes,
has not at all been stated in the FIR.
that's my humble submission.
Yes.
and 2 additions which have subsequently been deleted. Addition of that wife of Navin Nehuri, that ତା ମା ବି ବୋତଲରେ ପାଣି ଧରି ଥିଲା.
ଆଚ୍ଛା ଏଇ ଯୋଉ ଲାଇନଟା କହୁଛି ଯେ
both assaulted, that is not there. Both assaulted by X.
these are the omissions which you think.
2 additions, 2 omissions.
What are the omissions about the assault by both?
Both, that is the prosecution itself suggests not true.
Assault
And the
by
addition of lady, that she was also there holding a bottle dhari
assault by
asula.
both the appellants with Tangia.
Again.
It was the initial story.
Again.
That has been given a go by during trial.
In the sense, the son, there is no allegation of assault against the son.
Assault by Tangia. We are specifying.
He was not even holding. That is the
that.
ultimate case. କହି ରାଗରେ ଦୌଡ଼ି ଆସିଲେ ତା ପଛେ ପଛେ ତା ସ୍ତ୍ରୀ ମାନେ ନବୀନର ସ୍ତ୍ରୀ ବି ସେଠି ପ୍ରେଜେଣ୍ଟ ଥିଲା. That was deleted.
How many blows have been given to these 2 ladies? As for the PM report.
Multiple years.
Multiple.
One male.
Just see it.
So far,
who are the doctors who's conducted PM?
Doctor is only one. He conducted all the 3.
Who is the doctor?
PW6.
PW6 is the PM doctor.
So page 86.
Page 86.
And the Tangia, after seizure, it was also referred. His query is, it's possible. The description part.
One, two, right ear, another is in left cheek, then another is on the right side neck. That is so far as S.K.Sahoo is concerned.
Yes.
Then S.K.Sahoo.
Only one wound.
On the neck.
Neck.
Okay. So, what you are now submitting that even though so far as these 2 ladies are concerned, the witnesses are PWs 1, 3 and 4. The presence of PW 3 and 4 is not there in the first information report. Number 2, even though in the FIR it is stated that both the appellant assaulted by means of Tangia to these 2 ladies.
Yes.
That is been given a go by in the trial.
Yes.
Right?
Yes.
Only stated that this father assaulted by means of Tangia.
Only assault against Nabin. And the mother's presence is also
even if it is not stated that the son was having any Tangia with him.
Yes.
Right? That is your son.
Not anyway armed. Now, Millers, the next after affair, the inquest report. Lordship, may kindly have a look.
Just
the second paper book
is 252. 252.
Just a minute. So, the 2 ladies who are assaulted, they are mother and daughter.
Mother and daughter.
And the father is there in that field.
Not father. Son-in-law. Sabitri's husband.
Oh, acha, all right. Son-in-law.
Ma, Jio, Jwai.
Jwai. Male. 2 female assaulted here. 1 male assaulted there. He is the son-in-law. All right. What you are trying to point it out?
252. Second paper.
Second paper.
Because after, obviously, the inquest preceded after.
252. Yes, please. It is the inquest report of Pirovati Behera.
Again. opinion, column 9, opinion of witness caused to death.
कौन है ना opinion?
Of the witnesses as to cause of death.
Column number 9.
9.
हाँ,
ଆଜ୍ଞା।
पढ़ନ୍ତୁ।
ମୋର ଶାଶୁ ମା ବୀରବତୀ ବେହେରାଙ୍କୁ ନବୀନ ଦେହୁରୀ ଓ ତା ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆରେ ବାରମ୍ବାର ଶକ୍ତ ଆଘାତ ଦେଇ ମାରିଛନ୍ତି। And signed by Uday Chandra Pruseth.
Who is he?
He is the PW2. He is the husband of the informant. Informant and this Pruseth, her husband, they were staying.
PW2, in fact, is not an eyewitness.
No. Phone paila pare se asila. He, after, because he plays a main role here. Though the person doesn't have any information, he is not a witness. Now he states, ମୋ ଶାଶୁମା ପିରବତୀ ବେହେରାଙ୍କୁ ନବୀନ ଦେହୁରୀ ଓ ତା ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆରେ ବାରମ୍ବାର ଶକ୍ତାଘାତ ମାରିଛନ୍ତି. Assault by both. Though Pruseth, his wife, is a signatory here. But this man is the first information is not given by the wife, by her husband, who is not there in the picture, came subsequently. Then, my lords,
this lady who is the informant in this case,
yes,
is
one.
She is also a signatory to the inquest.
Inquest report in the bottom. But if at all this affair has been lost and she was there in the village, because she being there in the village, she is a chance witness. She doesn't stay there. She says on the previous night, I came with my children, my husband. On the next day, the husband goes back. After the incident, he was called. By whom? It's not known. Nobody says who called him. He comes back. By the time he comes back, thereafter police arrives. Then the proceedings commensurates. So what I intend to submit is, now these two children, they have been introduced as eyewitnesses. So far, this lady's presence even is doubtful, or can be, because in the inquest, when the process starts, the opinion of the eyewitnesses is not reflected in the opinion column. It's the opinion of a person who is not present reflects, implicating both the accused persons.
No, Mr. Sarangi, suppose this man was not present. He is the husband of the informant.
He heard it from his wife.
When he comes, obviously...
He says he heard it from his wife.
Right.
Yes. So what he heard from his wife is reflected here.
And is there any distinction between what he has reflected here and in the affair story?
Distinction in the inquest report itself. Next inquest report.
No. Because the FIR story is that
both
the assailant assault. Appellant assault.
So far, names of the accused persons are concerned, there is no deviation.
But what is the purpose of inquest? It is the apparent cause of death of the deceased that is reflected in that cause. So the person who sees the dead body and finds the nature of injury has to be
basic information. Next inquest report, next page, 253. ମୋର ନାନୀ ସାବିତ୍ରୀ ସାହୁଙ୍କୁ, again the same Uday Chandra Pruseth is the ମୋର ନାନୀ ସାବିତ୍ରୀ ସାହୁଙ୍କୁ ନବୀନ ଦେହୁରୀ, ତା ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଓ ତା ସ୍ତ୍ରୀ ଯୋଉଟା କଟା ହେଇଛି କରା ଦେହୁରୀ 3 ଜଣ ମିଶି ଟାଙ୍ଗିଆରେ ହାଣି ମାରିଦେଲେ। ତାକୁ କାଟିକିରି ତାପରେ କରାହେଲା 2 ଜଣ
ଦେହୁରୀ, ଆଚ୍ଛା 2 ଜଣ,
ତାପରେ କରାହେଲା ତାକୁ 2 ଜଣ। ଏଠି the Nabin's wife was added as an assailant. In the affair, her presence is there. Now in the inquest, that was added, that was deleted.
No, it's all right.
And the same person.
No, Mr. Sarangi, just what my brother has just pointed out, that even there is no necessity of mentioning the name of the accused in this column number 9. There is
No,
necessity.
it's only the knowledge of the opinion of the witness
Sometimes
to how it occurred.
Sometimes the investigating officer used to mention.
Yes, Milords. Milords,
So
even that is hit by 161. That is not even evidence.
Just
I
take pause for a moment. Just listen to it. So suppose this information which is brought to the knowledge of the investigating officer through the witnesses who are signatory to the inquest report is something different from the FIR story. It is
no, so far as the names of the assailant,
so
names are there. Both assaulted, it continued. What I intend to submit, Milords, from the very inception, there is an endeavor to try and entangle, and ultimately the son is entangled. I may not reach Nabin, but at least
এই জায়গাରେ মনে କରନ୍ତୁ
କିଛି ଲେଖା ହେଇନଥାନ୍ତା. That would have been fine.
ଗୋଟେ ଥାର୍ଡ ଲୋକର ନାଁ.
Yes.
ମୁଁ କହୁଛି ଗୋଟେ ଥାର୍ଡ
Here the third person's name was there, that has been deleted.
ନାଇଁ ଆମେ ଯିବୁ ସେଠିକି. ଆପଣ ଯୋଉ ପ୍ରଥମ ଯୋଉ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟଟା ଦେଖେଇଲେ ନା ସେଥିରେ ଯୋଉ ଦି ଜଣଙ୍କର ନାଁ assaultରେ ଇମ୍ପ୍ଲିକେଟ ହେଇଛି ଯଦିଓ ଦରକାର ନଥିଲା ସେମାନଙ୍କର ନାଁ ସେଠି କିଛି ଉଲ୍ଲେଖ କରିବା ପାଇଁ, but it is mentioned and that is the very name which find place in the FIR also, and obviously
And
this
from the
inquest report is
that is the in the FIR. That is what I am pointing out. Even if the son was not even holding a weapon, from the FIR till inquest, the initial story continued that both of them assaulted. So there is an intention even to implicate the mother. So there is an intention to go beyond Navin Deuri. So the initiation and the intention of the prosecution from the very inception is not fair, which can be doubted, which is questionable. Now the next, Milords. The Lordship sees it goes further, Milords. ଏଥିରେ ଶାଶୁ ଯୋଉ ତା ସ୍ତ୍ରୀ ନାଁଟା କଟା ହେଇଗଲା, 3 ଜଣରୁ 2 ଜଣ କରାହେଲା. ନେକ୍ସଟ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ, Milords, ସେମ୍ କଲମ, ସେମ୍ ପର୍ସନ. ମୋର ଷଢୁ ଗିରିଧାରୀଙ୍କୁ ନବୀନ ଦେହୁରୀ ଓ ତା ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆ ଓ ଛୁରୀରେ ଗୋଡାଇ ହାଣି ମାରିଛନ୍ତି. So one person, 3 reports, signatories are the same, and the opinion is totally 3 versions within seconds, minutes.
The person who has seen the assault on this man, Giridhari Sahu, whether he is a signatory to this inquest report?
No, probably.
What is
I
his
have to
name?
take no. I don't think PW5 is not a.
What is the name of PW5?
PW5 is
Prafullo
Kumar Naik. PW5 ବୋଲି ସେ ଡକ୍ୟୁମେଣ୍ଟ ତଳେ ଗୋଟେ ଲେଖା ହେଇଛି, କିନ୍ତୁ ହଁ, he is a signatory there.
No, he is there. Prafullo
Yes,
Kumar
yes.
Naik is
Yes,
signature has
sorry,
been marked also
his
as
signature is there.
exhibit P1. So this is
PW5 ବୋଲି ଲେଖା
PW5
ହେଇଛି.
is there, PW1 is there, and this is PW2. Udaya is PW2. So in presence of at least 2 eyewitnesses, the inquest was prepared, right?
Yes.
And even though
But their version is not reflected. Their version is not reflected. Only thing is, yes, names of the accused persons may not be required, but it contains. But the differentiation in 3 documents.
What is the statement? We are now focusing on this third inquest report, that is the inquest report of Giridhari Sahu.
Yes, ଏଥିରେ ଆସିଗଲା ମୋର ଷଢୁ ଗିରିଧାରୀ ସାହୁଙ୍କୁ ନବୀନ ଦେହୁରୀ ଓ ତା ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆ ଓ ଛୁରୀରେ ଗୋଡାଇ ହାଣି ଦେଇଛନ୍ତି.
It's all right. We are following you. This Prafullo Naik statement is that who assaulted the?
There is no mention about the presence of the son Hemananda.
Not at all.
Not at all.
Okay.
Only Navin has assaulted. Only
So you mean to say that even though the sole witness to the assault on the Giridhari Sahu is PW5, who is a signatory to the inquest report, but even though that PW5 has implicated only the father to be the assailant and not stated even the presence of the son.
And here it's stated the
Here is stated
puo
that-
chori dhari marla.
Okay, just
And vice versa, Milos.
just a minute. Please wait. You can just take a clue from that Jawaharlal Das case. There they have stated that this inquest report, it is not necessary to mention the name, but if it is mentioned and it goes contrary to the prosecution case, then what would be its effect? It is
Yes,
not at
obliged.
all necessary that who has assaulted, what is the weapon used, because this column 9 is something, it's for different purpose. So, but when it is prepared in presence of the witnesses who are the eyewitnesses to the occurrence, and different thing has been stated, what would be its evidentiary value?
Obliged.
That is.
That's what I said. It gives two impacts. One, it even doubts the integrity of the eyewitness concerned. Because here it all based on the relations of the deceased.
Just a minute.
There is no independent witness.
So, about this particular inquest report of this Giridhari Sahu, when the sole eyewitness to the assault of Giridhari Sahu is himself a signatory to the inquest report, and it is the version of that sole eyewitness that it is only the father who has assaulted Giridhari by means of Tangia, and the son was not at all present. But in spite of that, in the inquest report, it is mentioned that both the father and son assaulted by Tangia and Churi, knife.
Yes.
So
This is one other aspect. This throws impact on the veracity of the witnesses concerned,
Right.
because evidence and the recording of evidence of witnesses, even 161, they came after the inquest is over. So it also gives an reverse impact on the veracity of the witness concerned.
So PW1 has not ever stated about both the accused persons to have assaulted.
Yes.
Come to page 2.
Pardon.
Thereafter, both the accused persons restraining my sister went on giving
Not
reports
in the
by means
Millers,
of
we have not reached the evidence. FIR
then where you are? Only FIR.
ଆଜ୍ଞା FIR ତାପରେ ଇନକ୍ୱେଷ୍ଟ ତାପରେ ଆଜ୍ଞା ଯାଉଛି
evidence କୁ ସେ ଆସିନାହାନ୍ତି
ସେ ପାର୍ଟରେ ଅଛି ଯେ ସେ ରିଷ୍ଟ୍ରେନ୍ କଲା ବୋଲି that is how he has been implicated. Assault or holding a knife, these things which were at the inception stage.
What you mean to say exactly that the initial version which is there in the FIR, which is there in the inquest report, that they have changed to a great extent during trial.
And because it's fluctuating, the eyewitnesses, so-called eyewitnesses, were arranged rather than natural eyewitnesses when there is scope of houses, of presence of other persons. It's a very small town. and that cutting of crops were going on. It's natural. Everybody has a land there. No independent witness. 3 houses before the tube well who are also not. They had never heard anything. They never seen anything.
Just Mr.
That I will come to.
Don't make so fast. Go slowly. We have to pick up each and every point since it's a death reference case. So let us understand the.
reverse ago sentence part
No. Let's just since you see,
I know the seriousness with us.
why
Somebody's life is at stake.
why they change the version that is to be also seen
to
that
make it will be more suitable to the prosecution. It will to avoid the improbabilities, to avoid the vulnerability. And with all these years, what basic is the probability factor is a primary thing in a criminal case.
ଚିନ୍ତା କରନ୍ତୁ 3 ଜଣ ଯାକ ଯଦି ସାଙ୍ଗ ହେଇ ଯାଇଥାନ୍ତେ ଯୋଉଟା କି ଆପଣଙ୍କର ଏଫଆଇଆର ଷ୍ଟୋରି ହେଇଥାନ୍ତା ଏବଂ 2 ଜଣ ଏଠି ଅଟକି ଗଲେ ଆଉ ଜଣେ ପଳେଇଲା ସେ ପଡିଆକୁ ପଳେଇଲା ଯୋଉ ପଡିଆଟା ହଉଛି 3 କିଲୋମିଟର ଦୂରରେ
ସର୍ଟକଟରେ 800 ମିଟର
ହେଲା ସେଠି ଗଲା ଏବଂ ଏମାନେ ଟ୍ୟୁବୱେଲ ପାଖରେ ପାଣି ଥିବା ଅବସ୍ଥାରେ assault ଆରମ୍ଭ ହେଲା ଯୋଉ assault ପାଖରେ 2 ଜଣ ଯାକ accused present ଅଛନ୍ତି
ଯଦି ଟାଇମ ଗ୍ୟାପ ଟା ଛଡା ହେଇଯିବ 15 ମିନିଟ ଟା ସେମାନେ might have stayed back but this will not take that much time. By then they would have left the place after taking water.
ନାଇଁ ଆପଣ ତାଙ୍କ କେସଟା
and FIR another aspect minutely see what the informant has said. Hearing the cry, when she looked at where from the cry comes, she could notice the assault.
No, suppose the first assault took place there in the field,
yes,
in which according to PW 5 only one person was present. Then that gentleman who was assaulted, this father, he came to the second spot. This second spot is the, let us say,
he came by walk. This fellow came by the main road.
Shan
Girdhari. PW 5.
No. This we are focusing on the accused. Let us say that
accused first assaulted.
Father assaulted in the field. That is the first assault.
Yes.
Then father coming to the second spot.
Yes.
Second spot is near Tewell. Son was not there in the first spot. So son is also coming to the second spot. So both of them are reaching the second spot. Then second assault took place.
Yes. I will only pause for a moment. The houses, the tube well is 30 cubits or something away from the house. Line of houses, my house is before the house of the deceased persons, house of the informant.
My house means who's
accused persons. Okay. They are neighbors. The tube well comes after the house of the informant and the deceased persons. So if from my house I go to the tube well, I have to pass through their house. There is no other route to reach the tube well. If I come from the main road, then PW 5 comes. The father came through the shortcut by walk. The son, if he was in the house, he has to pass through the house of the informant who was very much present and witnessed the assault. So the presence of the son is an impossibility under the circumstances.
Son's presence. Son was
so in this background, when they try to improvise, my house first, then the house of the deceased, thereafter the tube well. So I go from anywhere, I have to pass the house of the informant to reach that tubewell. So father comes from a different direction.
After assaulting, yes.
PW 5 doesn't say about the son. Now, if the son goes from his house or elsewhere,
joins the father near the tubewell,
has to go to PW 1's house.
Yeah.
And there is no mention how. So his presence itself is highly improbable. And the background, he assaulted, then he obstructed, even obstructed past, there are variations, we'll come to that. So virtually the son's implication is pure and pure concocted.
No, son's presence there, that is not there.
Here also,
here tubewell,
he can,
here tubewell.
where from he came, he cannot reach that place without passing through the informant's house.
Okay, let us say he has passed through the informant's house, and after he passes through the informant's house, comes to the tubewell, then the informant comes from his house.
Presumption can be either way.
No, just visualize the situation. Father, after assaulting that man Giridhari in the field, comes near the tubewell.
Yes,
right.
Then Millers again will go back to
the two ladies are there near the tubewell.
Normal assessment that only when some occurrence or something or sound, it only then a witness is attracted. Witness is not naturally attracted or waiting that yes, here a murder will take place. I am waiting here. I will be a witness to that. Only when something happens, his or her attention is
you are now advancing an argument that the son's presence at the tubewell is an impossibility factor.
Yes.
Had it been so, it would have been noticed.
And suppose your lordship, what your lordship suggested, he passed, then the informant comes out, the assault takes place. By then he has passed, so there is no occasion for the informant
to see him.
But even then, my humble submission will be attracting 34.
No, that's a total different matter. So 34, whether that would be there or
so
not.
Even if probable,
somebody, if the case is that, you see, the father assaulting a lady, one lady, the
other lady try to intervene.
Daughter is going to interfere or rescue. Let us say to rescue. At that point of time,
he obstructed.
This is checking the movement. So this part, even if it is the prosecution case, it is like that a person also serves who waits. It is like on that theory, it has been waits and see that he also serves. So it is on that.
All right,
so
these are the things
restraining the movement.
These are the things for consideration.
So restraining somebody's movement,
impact on the reverse impact on the witnesses and the probability factor. Now, should I proceed to PW1?
So, restraining the movement of a witness from proceeding further to rescue one of the deceased, whether it attracts common intention or not, that is another factor, right? Because that you say that is the only allegation against the son. Am I clear? Are we correct?
Yes.
That is the only allegation. Though in the FIR it is stated that both of them assaulted.
Assaulted. Inquest, he was holding a knife. Other inquest, both are assaulted.
Now you can proceed.
Yes. PW1 Miller space 66.
You are want to place PW1. By the way, what is your defense plea? Total denial.
Total denial.
Okay. PW1 is at page
66. Last paper.
Okay.
I am the informant in this case. I have lodged report against the accused persons, namely Hemananda Dehuri and Nabin Dehuri, who are standing in the dock. This is Giridhari was my elder brother-in-law. This is Pirobati was my mother. And this is Sabitri Sahu was my elder sister. The alleged incident was happened on 21/10/2020. Since my parents has no son, my deceased brother-in-law was residing in my father's house as illetum son-in-law. On the previous day of the alleged occurrence, I had gone to village Lapada to my father's house. On the occurrence day, around 2:30 p.m., my elder brother-in-law went to the paddy field. After 15 to 20 minutes thereof, my sister and mother left the house to paddy field. That is what I'm saying, that the time gap comes here. And it comes here with an purpose. After their departure, I, along with my nephew and niece, these were not there. The son and daughter of my deceased sister.
This nephew is PW?
3, 4, PW, nephew and
Nephew
niece.
is PW3 or
Yes.
PW4?
No.
Son is PW3,
And
PW4 is the daughter.
Niece is PW4. Okay.
Son and daughter of my deceased sister came outside and was on our outer veranda. At a little distance from our house, there is a Jagannath temple, and nearby that temple, there is a tube well, and that tube well is visible to our house. I found my mother was pumping the tube well, and my sister was pouring water in a bottle. At that time, both the accused persons came and accused Nabin suddenly dealt a blow by means of an axe on the neck of my mother. Seeing this, my sister threw the bottle and went to rescue my mother, but accused Hemananda restrained my sister by dragging her hair. Accused Nabin gave consecutively 3 to 4 blows on the neck of my mother, and she died on the spot. Thereafter, both the accused persons, restraining my sister, went on giving blows by means of tangia on different parts of her body, and she also died at the spot.
This line is there. You said na taro ଅନ୍ୟଟା ନାଁରେ କିଛି ନାହିଁ ବୋଲି. So the FIR story that both of them assaulted by Tangia, it is also there in the evidence of PW1. Thereafter,
Both the accused persons assaulted.
Restrained my went on giving blows of Tangia on different parts of her body. So this line is there in the evidence.
Subsequently,
no contradictions have been pointed out.
Yes, because Miller sees the informant. FIR.
No.
Use of an FIR to corroborate or contradict the maker of it.
An impression as if the son has not at all assaulted. He just shake the movements of one of the deceased by
so far as assault part is concerned.
That is there in the FIR. That is there in the evidence also.
But when other witnesses and the IO himself says,
you mean to say that
subsequent
3 and 4 have stated
and
different.
other persons will ultimately it will come down. And she also doesn't say that the father was there or the son. She says both the accused persons came. So she has noticed before the assault.
Yeah, right from the beginning.
Before it started.
Right.
She says both the accused persons came.
Right.
That's why I said if this person goes, then it has to be through her house.
Please continue then.
Yes.
Okay.
The accused persons was telling loudly that they have killed my brother-in-law Giridhari. Out of fear, I, along with my niece and nephew, entered inside the house and closed the door. We raised hulla, hearing to which the villagers came to the spot. I narrated the entire incident before the villagers, and thereafter I went to our paddy field and found my brother-in-law was lying dead there. There was mark of injury on his head, neck, and hand. Getting information after about 1 hour of this incident, police arrived at the spot. I submitted a written report at the spot to the police. As per my statement, the report was written by one Kalyan Behera. He has been examined PW8.
PW8
8.
8 है तो
Again.
Okay.
He, after writing the same, read over the contents thereof to me, and finding the same to be true and correct, I put my signature. This is the said affair marked as so and so, so and so. Police held inquest over the dead body of the deceased persons and accordingly prepared 3 separate inquest reports, and I put my signature on all those reports as a witness. Exhibit so and so, report of my mother, so and so, so and so. In the inquest, brother-in-law. Much prior to the alleged incident, since the time of my grandfather, there was land dispute among we both the families, and for that dispute, the alleged incident happened. Prosecution. It is not a fact that it's a very recorded in a very peculiar way. My lords, the affair is the purpose is to corroborate or contradict the maker of it. Now, yes, it has done in such a manner. It is not a fact that I had not stated before the police that being called by my brother-in-law one day prior to the incident, I had come to village Lapoda. It is not a fact that I have neither mentioned in my affair nor stated before the police that at about 2:30 p.m. my elder brother-in-law went to paddy field. Thereafter, 15 to 20 minutes of his departure, my mother, my elder sister left the house to go to the paddy field. And after that departure, I, along with my nephew and the whole chief that has been quoted.
This is not there.
In the 161, it's there. FR, it's not there.
No. Just let us be clear. Whether it is not there in the 161 also.
No. In the 161, it's there. That
Then
name of a nephew and
allowed to put such question. If it is not, it is there. Let us then just Mr.
Both, he has mixed it
So
both.
then it has to be proved through the investigating officer.
But FIR part, not required. Lordship knows.
FIR, the you, ଆପଣ ଯୋଉ 161 ର ଯୋଉ confrontation ଟା
then only it becomes a contradiction.
ସେଇଟା IO through ରେ ପ୍ରମାଣ ହେଇଛି ତାକୁ.
Yes, you also can come to page 134.
Let us see that. That portion.
161 part, I'm again clarifying, my lords, is what the deposition comes. But affair is these things lacked.
Paragraph 27 starts.
Just please come to Mr. We'll see that. Come to 134, paragraph number 27.
It is not a fact that witness, namely Monikia,
it is not a fact that she is denying.
Yes.
Has
not stated before me in her statement that she being called by her brother-in-law one day prior to the incident had been to village Lapoda, and that at 2:30 p.m. his sister, brother-in-law, the whole para.
So what does it mean that in fact there is no contradiction? If Miller's he stated that it is not a fact.
Yes.
That means the defense counsel
161 part is she is not only, she is also the informant. So if the FIR comes into play and FIR stands in a better position than the 161 by a police. So if it contradicts the FIR, it's a development beyond the FIR.
ଆପଣ ଗୋଟେ ସାକ୍ଷୀ କୁ କହିଲେ ଯେ ବାବୁ ଦେଖ ତୁ ଯୋଉ ପୋଲିସ ପାଖରେ ଯୋଉ ଜମାନବନ୍ଦୀ ଦେଇଛୁ ଏଇ ଜିନିଷ
what I have said, that recording is, it should have been, you have not, FIR is different, 161 is different. That should have been the cross-examination pattern.
Separately
so that is how a confusing result comes out.
ବର୍ତ୍ତମାନ ହେଲା FIR. Let us then, in the interest of justice, we can see that 161. There is no problem in that. 161 ଟା ଦେଖିବା ଏଇ ସାକ୍ଷୀର ବାହାର କଲେ ତ trial court record ରୁ ବାହାର କଲେ
Monak Prusset.
161 of this PW1 Manikya Pures.
Manik Prusset.
এই କପିଟା ବାହାର କରିକିନି ମିଷ୍ଟର ଷଡଙ୍ଗୀଙ୍କୁ ଦିଅନ୍ତୁ। ଇମିଡିଏଟଲି ଦିଅନ୍ତୁ।
That most probably is there.
Just let us see. You must also see that
If she would not have been the informant, then nothing wrong about it. But once she is also the informant, then FIR comes into play.
no, obviously you are right, but just we want to hand over the
Yes.
161 to you. Just have a look at it.
I would have done it.
Bring out 2 copies. Hand over one to Mr. Khatkia, the other one to Mr. Sarang. And now you come to the FIR. Please place it so that it can be very clear.
FIR?
No, this 161.
160. ମୁଁ ଶ୍ରୀମତୀ ମାନିକପୁର ସୁଆଂଶୁ ଜିଲ୍ଲା ସୁଆଂଶୁ ଆଜି 21/10/22 ରିଖ ଦିନ ଆପଣଙ୍କୁ ଦେବା ମୋର ବୟାନ ହେଇକି ଯେ ମୋର ବାପା ମୃତ ଦୁଃଖ ବେହେରାଙ୍କ ଆମ୍ଭେ 2 ଝିଅ ଅଟୁ। ବଡ଼ ଭଉଣୀ ସାବିତ୍ରୀକୁ କିରିମିରିଆ ଗ୍ରାମର ଗିରିଧାରୀ ସାହୁଙ୍କୁ ବିବାହ କରାଇଥିଲୁ ଓ ମୋ ମା ବିବାହ କାର୍ଯ୍ୟ ମୋ ଶ୍ୱଶୁର ଘର ଖଣ୍ଡକୋଟରେ ରହୁଅଛି। ଆମର ପୁଅ ନଥିବାରୁ ବାପାଙ୍କ ମୃତ୍ୟୁ ପରେ ମୋର ବଡ଼ ଭଉଣୀ ଓ ତାର ସ୍ୱାମୀ କୁ ଆମ ଘର ଜ୍ୱାଇଁ ଭାବେ ରଖିଅଛୁ। ସେମାନେ ଆଜକୁ 17-18 ବର୍ଷ ହେବ ଲାପଟା ଗ୍ରାମରେ ରହୁଛନ୍ତି। ଆମ ଘର ବାପା ଅଜା ସମୟରୁ ଆମେ ପଡ଼ୋଶୀ ନବୀନ ଦେହୁରୀ ବାପା ଅଜା ସହ ଜମିବାଡ଼ିକୁ ନେଇ ଝଗଡ଼ା ଲାଗି ରହିଛି। ବାରମ୍ବାର କୋର୍ଟରେ କେସ୍ ସେମାନେ କରୁଛନ୍ତି, ହେଲେ ସେମାନେ ହାରିଛନ୍ତି। ଆମେ ଉକ୍ତ ଜମିକୁ ଭୋଗ କରି ଆସୁଅଛୁ। ମୁଁ ଗତକାଲି ଦଶହରା ନିମନ୍ତେ ଆମ ଘରକୁ ବୁଲି ଆସିଛି। ମୋର ସ୍ୱାମୀ ମତେ କାଲି ଗାଁରେ ଛାଡ଼ି ଆଜି ସକାଳୁ 10ଟାରେ ଗଲେ। ସକାଳେ ମୋର ମା, ବଡ଼ ଭଉଣୀ ସାବିତ୍ରୀ ଓ ଭିଣେଇ ଗିରିଧାରୀ ଜମିର ଧାନ କାଟିବାକୁ ଗଲେ। 12ଟାରେ ଫେରି ଆସିଲେ। ମୁଁ ରନ୍ଧାବଢ଼ା କରିଥିଲି, ସବୁ ଖାଇଲୁ ଓ ଟିଭି ଦେଖୁଥିଲୁ। ପୁଣି 2:30 ହେବ ସେମାନେ ଧାନ କାଟି ଜମିକୁ ବାହାରିଲେ। ମୋର ଭିଣେଇ ଆମେ ଆଗ ଗଲେ। ପର ଅଧଘଣ୍ଟା ହେବ ଆମର ଭଉଣୀ ଓ ମା ଦୁଃଖ ସୁଖ ଓ ମୋର ଭଉଣୀ ପୀରବତୀ ଧାନ
ସାବିତ୍ରୀ ଓ ମା ପୀରବତୀ
ଧାନ କାଟି ଗଲେ। ସେମାନେ କବାଟ
ଆଉଜେଇ ଥିଲେ, ହେଲେ ମୁଁ ଅଳ୍ପ ସମୟ ପରେ କବାଟ
actually there is a version that ସେ କବାଟଟା ଛାଡ଼ି ଦେଇଥିଲେ, ସେଇଥିରେ ଦେଖିଲି ସେଟା
କବାଟଟିଏ ଦେଇ ବାହାର ବଖରାକୁ ଆସିଲି। Now you read. ମୋର ପଛେ ପଛେ
ମୋର ଝିଆରୀ ସ୍ୱପ୍ନା ଓ ପୁତୁରା
they are PW 3 and 4. Okay.
ମଧ୍ୟ ଆସିଲେ। ସେତେବେଳେ ମୋର ମା ପୀରବତୀ ଗ୍ରାମ ପଞ୍ଚାୟତ ନଳକୂଅ ଯାହାକି ଆମ ଜମିକୁ ଯିବାର ରାସ୍ତାରେ ଅନୁ ଚୌଧୁରୀଙ୍କର ଘର ଶେଷରେ ଅଛି, ସେଠି ପାଣି ମାରୁଥିଲେ ଓ ମୋ ଭଉଣୀ ବୋତଲରେ ପାଣି ଭରୁଥିଲା। ଏହି ସମୟରେ ଆମ ପଡ଼ୋଶୀ ନବୀନ ଦେହୁରୀ ପିତା ସୁଆଂଶୁ ମୋର ମାକୁ ଟାଙ୍ଗିଆରେ ହାଣିଦେଲା। କଣ ହେଇଛି ମୋ ମା ଏମିତି ଚିତ୍କାର କଲା କହି ମୁଁ ଟିକେ ବାହାରକୁ ବାହାରିଲି। କବାଟ ପାଖେ ଦେଖିଲି ନବୀନ ଦେହୁରୀ ମୋ ବଡ଼ ଭଉଣୀ ପଛେ ପଛେ ଗୋଡ଼ାଉଥିଲା ଓ ଗାଁ ଦାଣ୍ଡରେ ତାକୁ ମଧ୍ୟ ଟାଙ୍ଗିଆରେ ଚୋଟ ଉପରେ ଚୋଟ ମାରି ଚାଲିଲା। ଏହି ସମୟରେ ନବୀନ ଦେହୁରୀର ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ମୋର ମାକୁ ମାରିବା ସମୟରେ ସେଠି ଜଗି ରହିଥିଲା ଓ ଭଉଣୀ ଦୌଡ଼ିବା ସମୟରେ ଛେକି ରହିଲା। ଫଳରେ ସେମାନେ ସେଇ ସ୍ଥାନରୁ ଖସି ଯାଇପାରିଲେ ନାହିଁ। ଏହା ଦେଖି ଆମକୁ ଆମକୁ ବି କାଳେ ମାରିଦବ କହି ଆମେ ତିନିହେଁ ଘର ଭିତରକୁ ଦୌଡ଼ି ପଶିଗଲୁ ଓ ଚିତ୍କାର କଲୁ। ଦେହୁରୀ ତା ଘରକୁ ଗଲା ବେଳେ କହିଲା ଯେ କିରିମାରିଆକୁ ସେ ବାଟରେ ହାଣି ଦେଇଛି। ଆମ ଚିତ୍କାର ଶୁଣି ଗାଁ ଲୋକ ଦୌଡ଼ି ଆସିଲେ ଓ ସମସ୍ତେ ମିଶି ମୋର ଭିଣେଇକୁ ଖୋଜିବାକୁ ଗଲୁ। ସେତେବେଳେ ଗାଁ ଦାଣ୍ଡରେ ମୋର ଭଉଣୀ ମୋରି ରକ୍ତାକ୍ତ ଅବସ୍ଥାରେ ପଡିଥିଲା। ମା ନଳକୂଅ ଚାନ୍ଦିନୀର ମରି ପଡିଥିଲା ଏବଂ ଭିଣୋଇକୁ ଦେଖିଲୁ ସେ ଧାନ ଗ୍ରାମ ଜମିରେ ମରି ପଡିଥିଲା। ମୋର ଭଉଣୀ ସାବିତ୍ରୀ ସାହୁ, ଭିଣୋଇ ଗିରିଧାରୀ ସାହୁ ଓ ମା ପିରବତୀ ବେହେରାକୁ ଆମ ଗ୍ରାମର ନବୀନ ଦେଉରୀ ଓ ତା ପୁଅ ଦୁହେଁ ପୂର୍ବ ରାଗ ଓ ଜମି ଜମା ମାମଲା ନେଇ ହତ୍ୟା କରିଅଛନ୍ତି। ଏଣୁ ଏଇ ଯେ ଗାଁରେ କହିବା ପ୍ରକାର
ଠିକ ଅଛି। ତ ଏଠୁ ଯାହା ଜଣା ପଡୁଛି ଆପଣ ଯୋଉ କଣ୍ଟ୍ରାଡିକ୍ସନ୍ସ ତାକୁ ଆଣିବାକୁ ଚେଷ୍ଟା କଲେ ଯେ ସେଗୁଡାକ ଇନଫ୍ୟାକ୍ଟ ଅଛି, ଏକ୍ସେପ୍ଟ ଅଫ କୋର୍ସ ଏଇ ଯୋଉ ଦି ଜଣ ଯାକ ଯୋଉ ଟାଙ୍ଗିଆରେ ମାରିଲେ, ଯୋଉଟା କି ସିଏ କହୁଛି ତାର ଡିପୋଜିସନ ରେ, ସେଇ ଜିନିଷଟା 161 ରେ
ନାହିଁ, ସେଟା ରିଷ୍ଟ୍ରେନ୍ କୁ କନଭର୍ଟ ହେଇଯାଇଛି।
ହଁ, ସେଇଟା otherwise
the role of the other accused and second thing, ଏଥିରେ ସେମାନେ କହିଲେ ଗଲା ବେଳକୁ ଦୁଆରଟା ଆଉଜେଇ ଦେଇଥିଲା, ପୁରା ବନ୍ଦ ହେଇ ନଥିଲା। ବନ୍ଦ କରିବାକୁ ଗଲା ବେଳୁ ସେ ଦେଖିଲେ which part is not there in the deposition or in the FIR. ଏଟା ଇଣ୍ଡିଭିଜୁଆଲ ଯଦି ଆନ୍ସର ଗୁଡା ଲେଖା ହେଇଥାନ୍ତା ଟିକେ ବେଟର ହେଇଥାନ୍ତା। ଟୋଟାଲ ଟା ପୁରା ସେଗମେଣ୍ଟ
ଆପଣଙ୍କର ଯୋଉ କାଉନସିଲ ସିଏ ପ୍ରଥମେ ଭୁଲ କରିଛି। 161 ରେ ଯୋଉଗୁଡାକ ଅଛି ସେଗୁଡାକ କହିନ ବୋଲି କେମିତି ତାକୁ ପଚାର ଲାଗେ।
ନାଇଁ, ସେ କୋର୍ଟ ଦିଟା ପାରା ଏପଟେ ବି ଗୋଟେ ପାରା ସେପଟେ ବି ଗୋଟେ ପାରା, ଆଇଓ ପାଖରେ ପାରାଟା ସେ ପୁରା ଥୋଇ ଦେଇଛନ୍ତି।
ଏଫଆଇଆର ଟାକୁ ଅଲଗା ପଚରା ହେଇଥାନ୍ତା, 161 କୁ ଅଲଗା ପଚାରିଲେ ବେଟର ହେଇଥାନ୍ତା। ବଟ ଯୋଉଟାକୁ 161 ରେ ଅଛି ଆପଣ କେମିତି ତାକୁ ପଚାରିଲେ? ତା ଦ୍ଵାରା କଣ ହେଲା କି ନା ଏଇ ଯୋଉ ଆଇଓ ଯୋଉ ମନା କଲା ଯେ ହଁ ସିଏ ସବୁ କହିଛି, ତା ଦେହରେ ଏ ଜିନିଷଟା ବି ପଳେଇଲା। ଏଇ ଯୋଉ ପୁଅର ରିପିଟେଡଲି ଆପଣ ପଚାରିଲେ ନା, ଆପଣ ଏଇ ଯୋଉ ପୁଅ ତାକୁ ରିପିଟେଡଲି ଆସଲ୍ଟ କରୁଥିଲା ବୋଲି 161 ରେ କହିନାହାନ୍ତି। ଇନଫ୍ୟାକ୍ଟ ସେ କହିନି, କିନ୍ତୁ ସେ କହିଲା ହଁ କହିଛି। କାହିଁକି ନା ସେଇଟା ଗୋଟେ ପୁରା ଟୋଟାଲ
ପାରାଟାକୁ
ଆଣିକି ଥୋଇଦେଲେ।
ଏଇଟା ଏଇ ଯୋଉ ଏବେ କପି ପେଷ୍ଟ ହଉଛି ତାର
ସେଇଆ ହିଁ କରିଛି, ଟ୍ରାଏଲ କୋର୍ଟ ସେଇଆ ହିଁ କରାହେଇଛି, ପୁରା ଟୋଟାଲ ଆଣିକି ଥୋଇଦେଲା ସେଠୁ କପି କରି। ଅଦରୱାଇଜ ଇଣ୍ଡିଭିଜୁଆଲି ଦେଖିଲେ ଏଇ ପୋର୍ସନଟା ନାହିଁ।
ବ୍ୟାଚ୍ କେସରେ ଏବେ ଜେରା କରାହଉନି, ସେ ଆରର ଖାଲି ନମ୍ବରଟା ବଦଳେଇକି ପେଷ୍ଟ ହେଇଯାଉଛି।
ନବୀନ repeatedly dealt 3 to 4 blows on the neck of my mother। ଏଇ ଯୋଉ ଜିନିଷଟା ଇନଫ୍ୟାକ୍ଟ ନାହିଁ 161 ରେ, କିନ୍ତୁ ସେ ଆଇଓକୁ ଯେତେବେଳେ ପଚାରିଲା ଆଇଓ କହିଲା ହଁ ମତେ କହିଛି। କାହିଁକି ନା ସେ ଅନ୍ୟ ଜିନିଷ ଗୁଡାକ ଯୋଉଗୁଡାକ ସିଏ କହିଛି ଆପଣ କହିଲେ କହିନି, ତେଣୁ ତାରି ଭିତରେ ସେଇଟା ବି ଚାଲିଗଲା। But whatever it may be, fact remains that this portion relating to the assault by the son, that is not there in the 161 statement, even though she has stated about the same in the FIR, right? Yes. Okay, so after this contradiction, paragraph 3, you place now paragraph 4, because paragraph 3 is relating to that contradiction. Yes. So that is there. Eta kete page re baharla
68
nahi because jota ame jayuthulu seta 134 page 134 paragraph 27 pw kete hain pw plus 20 IO pw 20 yes IO page 134 paragraph 27 all right 27 page 134 and 135 135 right. Okay, now you come to paragraph number 4 page 68.
Yes, it is a fact that there is no endorsement in the report by exhibit P1 that the contents of the report thereof was read over and explained to me, and admitting the same to be true and correct, I put my signature. I have read up to class 10. Since I was shocked and trembling, I could not scribe the affair and requested Kalyan Behra to scribe the same. My in-laws' house is at village Kondokota. I reside there. My father's house is about 30 kilometers distance from my in-laws' house. At the relevant time, my mother Pirobati, my grandmother Hirabati, my brother-in-law Giridhari, my sister Sabitri, my nephew Sachin, and my niece Swapna were only residing in my father's house. Besides them, no other person was residing in the said house. Her children were also there, the other witnesses say. That's it doesn't say. At the time of incident, myself, my two sons, thereafter, Deepak and Dinesh, and my nephew Sachin and my niece Swapna were present in the house. On being asked by the court, the witness states that Deepak was aged about 13 and Dinesh was aged about 7. That's what I'm submitting, because it's a curiosity. Once two children goes, means the whole team, they run. That is the usual behavior. So many civil cases are filed among we both the families, but I cannot say the said cases were filed in which courts, by whom, and when. But the witness states that in all the cases the decree was passed in their favor. At the time while this incident, of this incident, no other person was present nearby our house. In between our house and the tube well, there were the houses of Susila Chaudhary and Tikeshwara Naik. It is not a fact that besides those two houses, there are also houses of Bhaskar Naik, Santosh Patel, Binod Naik, Rameshwar Chaudhary, and Buddhadam Naik. The witness states that Bhaskar Naik is the father of Tikeshwar Naik. It is not a fact that the tube well is not visible from our house, as it is obstructed by the house of Bhaskar Naik. I saw the occurrence from a distance of 20 cubits. I cannot say if any weapon was armed by accused Hemananda, but accused Nabin Deuri was holding a tangia. Hemananda ki? Aye, puo, joda mu kotli. Joda pole dilute hegala because of the cross examination. I cannot say any weapon was armed by accused Hemananda, but accused Nabin Deuri was holding a tangia. It is a fact that adjacent to our house, the house of accused person is situated. It is a fact that in order to go to the tube well from the house of accused persons, one has to cross our house. That is what I am pointing out. I cannot say the size of the said tangia. I cannot say exactly how many blows were given by accused Nabin to my mother. Assault was given to my mother only on her neck. All the blows were given from the back of the neck of my mother. The wearing sari and blouse of my mother were stained with blood. So far as I remember, my mother had wore a green color. Accused Nabin had wore a lungi, and Hemananda wore a pant and a shirt, but I do not recollect if he had wore a full pant or a half pant. I also do not recollect the color of the pant, but so far as I remember, it was a green color shirt. I do not recollect the color of the lungi. There was bloodstain mark on the body of the accused persons. Let's pause for a moment. The immediately after arrival of the police, that is there in the accused person, the accused persons were taken, confined. Because villagers may get agitated, what the police said, they're a threat to their life. From then onwards, they remain in the custody of the police till they are forwarded to court. So this blood stain on their body and other things, nowhere it's available. No, their clothes were not seized. Yes. And must have been sent also to the forensic science laboratory. Even they said even the son, nothing was found. That is separately we'll come back. There was bloodstain mark on the body of the accused persons, not wearing apparels, body. I cannot say if any other person had witnessed this incident. While Nabin was assaulting, accused Hemananda was holding my sister. I cannot say exactly how many blows were given to my sister, but 5 to 6 blows were given to her. My sister had received cut injury on 3 places on her head. 1 cut injury, her cheek, 1 cut injury on her neck, and 1 cut injury on her right hand. The earth on the place where assault was given to my sister was stained with blood. Her sari and blouse were also stained with blood. My sister was wearing a pink color sari, but I do not recollect the color of the blouse. Due to tangia blow on her hand, her blouse was torn on that place. After assaulting, the accused persons went to their house. Again says, I cannot say where they went, as I entered inside my house and closed the door. But while I came outside, at that time they were in their house. The accused persons had not told anything to me or Swapna or Sachin. After about 10 to 15 minutes of this incident,
Why did you bring this line, Mr. Sarangi? Come to this particular line 1, 2, 3, 4, 5, 6, 7. 7 lines from the bottom of page 69.
yes,
While
while
Naveen
was assaulting, accused Hemananda was holding my sister.
This was not the case in the 160 in the chief examination. It goes against you. What is not there in the chief examination, you have brought out in the cross examination. It's a dangerous thing. You see what he has stated in the chief examination is that Naveen, when Naveen assaulted, nobody was restraining the movement of the mother. It is
restrained by sister.
only sister. So sister was coming to rescue the mother, and sister's movement was rescued. But once you bring this line, when Naveen was assaulting, acha, it is Naveen was assaulting whom?
Assaulting
Savitri.
mother.
Mother. Acha.
Has to be because
acha. I thought that sister, when he was assaulting the sister, he was holding the sister. That means it was no. So this Naveen was assaulting means Naveen was assaulting the mother. At that point of time, he was holding the sister. All right, restraining the movement to prevent him to rescue the. Okay, to all right. Proceed. Yes.
Because so far as the mother is concerned, only one blow on the neck, finished. Thereafter, sister. After assaulting the accused persons, para 9,
yes,
went to their house. Again says, I cannot say where they went as I entered inside my house and closed the door. But while I came outside, at that time they were in their house. The accused persons had not told anything to me or Swapna or Sachin. After 10 to 15 minutes of this incident, while the villagers came,
these Swapna, Sachin are these
witnesses, niece and nephew of this informant.
3 and 4, no?
3 and 4.
Who is 3? Swapna
is
Sachin
4.
is 3, Swapna is 4.
Swapna is 4 and Sachin is PW. All right, please proceed.
The accused persons had not told anything to me, Swapna or Sachin. After about 10 to 15 minutes of this incident, while the villagers came, I came outside. Near about 20 to 25 persons were present while I came outside. They were Tikeshwar Naik, Govinda Naik, Papun Chaudhary, Valasini, so and so, and others. I narrated the incident before all of them. First I told Dibyoraj Naik and then to Govinda Naik. It is a fact that I have seen assault on my brother-in-law. এটা ভুল লেখা হয়েছে, not হওয়া কথা, মানে এটা পসিবিলিটি নেই, নটটা পড়েছি. It is not a fact that the deceased persons were not killed by the accused persons and they died coming into contact with the harvester, the machine which is being used to cut the paddy crop.
Paragraph 10 ଆପଣ କହୁଛନ୍ତି ଏଟା I have not seen ହବା କଥା.
ଗିରିଧାରୀର assault ବେଳକୁ
ହଁ ନାଇଁ ଇଏ ଦେଖି ନାହାନ୍ତି
ସେଟା ନଟଟା ପଡିଛି.
ନଟଟା ଓମିଟ ହେଇଯାଇଛି. ହଁ.
It is not a fact that deceased persons were not killed by the accused persons and they died coming into contact with the harvester, the machine which is being used to cut the paddy crop, and we had land dispute with the accused persons. We have falsely implicated them in this case, and to support our case, I am deposing falsehood. Besides me, Prafulla Naik, Devaraj Naik, Govinda Naik, and Uday Chandra Puset had also put signature on the inquest report. Now, my lords, he does not at all state about the existence of PW5, the witness to the first incident in the land. That PW5 witnessed the incident and informed or stated or anything.
No, he has not stated.
No.
But the accused persons, while leaving the place, they stated that we have already finished. I think.
No, I am on the other sole eyewitness so far as the field incident is concerned. He's PW5. Here, there is no reference that the other man saw or we came.
Where is the scope of PW1? had she stated, then she would have been contradicted because there was no scope for her to see.
No, no, no.
Who else has
The
seen
witness, that the said witness came to us and informed that
afterwards.
afterwards.
Okay, afterwards. You are right. Afterwards, he has seen ତାଙ୍କୁ information ଦେଲା ଏଇ ଜିନିଷଟା ସେ କହିଲା. You are right.
Because that witness states that. I will come to that.
Okay.
Then
that means you say that PW5 has stated that after the assault was over, I came and informed PW1.
Yes.
That is not corroborated by PW1. That
no
is,
witness states about the presence of.
all right. But so if we, you have now placed the evidence of PW1. PW1's implication, so far as these two appellants are concerned, it is the specific overtact has been attributed to one of the, particularly so far as the actual assault is concerned, it is attributed against that Nabeen. Though one line has been stated in the chief examination
both
that
assaulted.
both assaulted,
FIR both assaulted.
but in
Subsequently,
fact,
she says
cross-examination from it appears that the only role that has been attributed to this son about the restraining the movement of the sister, that
daughter, when one
right,
go to
daughter,
the
by holding
mother.
while she was coming to trying to,
this part was not there in the affair nor in the chief.
Which part?
That this restraint part was not there in the FIR at all.
FIR it 9.
Both assaulted continued in the from the inquest onwards. Then this FIR, first time the obstruction story comes into existence. That assault story goes, the obstruction story is introduced here.
Obstruction story ta chief re madhya achi.
ଏଇଥିରେ ଆସିଲା first time.
ଏଟା trial ରେ ଆସିଲା.
FIR inquest ସବୁ ପରେ ଏଥିରେ ଆରମ୍ଭ ହେଲା.
ନାଇଁ 161 ରେ ଅଛି ପରା ଆମେ ପଢିଥିଲେ.
Yes. FIR, I am on the FIR.
You are right.
I am from the very beginning. I am saying, if she would not have been the informant, then of course, basing on the IOS version, her evidence stands. But as because she is the FIR, she is the informant, the FIR is to corroborate or the contradict the maker of it. So there is not required to be any examination or confrontation to the IO, because a document, that is the only document which is exhibited. So it's on record. So the contradiction appearing in the version of the informant, so far as his deposition is concerned,
make it in this way.
Even if the 161 may be different, but still the FIR contradiction can be looked by the court irrespective of that 161. 161 is, though Lordship has looked into, even if that part is said that there is no contradiction so far 161 and deposition, but there are contradictions so far as FIR and the deposition is concerned.
Mr. Katkia, just take note of this point. It's a point that the person who is lodging the FIR, in the FIR is mentioning that two appellants used sharp cutting weapon like Tangia to assault the two deceased. Clear? Immediately thereafter, the 161 CRPC statement is recorded. In the 161 CRPC statement, one of the accused, means the son, is totally exonerated that he is having any weapon at all. The only role that is attributed against him in the 161 is that he restrained the movement of the Savitri, that by holding the tuft of the hair. So what would be the evidentiary value of a witness who is making such type of statement, or whose evidence is contradictory in this way, relating to the implication of one accused? Other accused, it is consistent that they assaulted by Tangia to both the deceased, and that is also there in 161, and also they are in the deposition. the discrepancy which he is pointing out is with reference to the overt attributed against the son, Naveen.
Which is absent in the affair. And one line further, my lords. If the assault part is, which is there in the 161 and the deposition, is found to be false, and this version is not available in the affair, which is a contradiction. One part is that intervention part is not their affair. It's a subsequent development done with her intention. The other part, which is consistent with 161,
whether such a witness can be said to be an absolutely reliable witness. That is one aspect.
And second aspect is, if the assault part is overall evidence indicates the assault part so far as the hammer and the son is concerned is excluded, and this implication is a subsequent development. So ultimately it boils down that he has been falsely implicated.
Just a moment.
The assault part may be consistent with 161, but overall, end of the day, if it is found that neither he was holding any weapon nor he has assaulted, then the assault part goes.
Just.
Deposition vis-a-vis 161. Assault.
So, Mr. Sarangi,
161.
if we go to the legal aspect,
Yes.
that let us say that in the evidence of a witness, the grain and the chaff has been mixed together. Okay. Then it is the duty of the court to separate. But if it is so intermingled that it cannot be separated, then obviously the court should not take the risk of relying on that witness. Okay. And what it says that three types of witnesses are being seen. One is wholly reliable, one is wholly unreliable, one is partly reliable and partly unreliable. And if it is wholly reliable, no corroboration is necessary. Wholly unreliable, you are to discard the evidence. If it is partly reliable and partly unreliable,
necessity comes
corroboration from independent source is required.
Witness is highly interested. Then the question
yes,
of
another thing that is highly interested. You
then
say.
the question of corroboration comes.
No, do you mean to say that relative witnesses are necessarily interested witnesses?
Not always, Lords. If a occurrence took place in the house, obviously the relatives will be the witness. They are the
So,
natural witnesses.
When
I'm not on that.
when this witness PW1,
I am on the version that two versions, FAI and 161. Role of examination of an FAI to corroborate and contradict the maker of it. So far as 161 is concerned, it's only to contradict and confirm it through the IO, by confronting the IO. So far as assault in both, if that part is disbelieved, then what remains? This intervention part by the other accused. Intervention part is absent in the FAI. So intervention part becomes a subsequent development with an intention to implicate him. So if the assault part is excluded by the overall circumstances of the evidence gathered, and that is excluded, then what remains is the intervention part. Intervention part cannot be accepted in toto as because the informant himself or herself has not mentioned about the same in the FAI. So that becomes a subsequent development with an intention
you
to
are right.
implicate somebody.
You are right.
Then it becomes a material contradiction and has to be.
You are right. Let us see that A and B are two accused. Okay. A and B, in the FIR, it is stated that A and B both assaulted by Tangia. In 161 and in the trial court, it is stated that it is only A who was assaulted by Tangia. The role which has been attributed to the B is that he restrained movement of one of the deceased in saving the other deceased. So the role attributed to B in the FIR is changed in 161, and
if the state she would not have been the informant, then no issue.
It's all right. So what you mean to say that merely because the role attributed by this particular witness informant in the FIR vis-a-vis 161 and deposition in court is contradictory to the implication of one of the accused, that is B, can it be a ground to not at all place any reliance on his evidence, even relating to the overt which is attributed against appellant A?
It's solely on this basis, it cannot be. In addition to that, first, she is an interested witness. Second, she will be a chance witness. She doesn't stay in that village. Accidentally, she came there. She says she came there. That is why I hinted at the inquest report where her husband becomes the main witness. Her husband comes after the occurrence takes place. So what I'm hinting at, even the presence of PW1 and her husband came subsequently. So even PW1, the presence becomes a bit doubtful. Overall, that is why they try to introduce two witnesses who belong to that place. The reason for introducing these two witnesses and the reason in the improvisation and the reason of being her present there. Overall, it makes her version doubtful. And normally, if a version is so integrally related, if one part fails, the other part is bound to fall.
Okay, again, we will come to that part which you are now harping. Let us say
that we can, after the totality of evidence is looked into, that aspect can be ultimately decided.
Okay, you say that since
I am only confining to this.
Okay, just the
161 FAI,
the presence of the other two witnesses, that is PW 3 and 4,
yes, introduced with an purpose,
is doubtful because it is not mentioned in the first information report by PW1 that those two witnesses were present at the scene of occurrence and saw the occurrence, right? So that is the only argument you are advancing that in the FIR,
this is not a small thing, my lords. Introducing two witnesses, eyewitnesses in a murder case, and FIR, yes, FIR need not be the cyclopedia. It should contain every detail, but it depends upon the time factor. Coolly, after relaxation, an FIR has been lost. Hurriedly, an FIR has been lost. Who lost the FIR? Her or his state of mind. That the overall thing makes the FIR.
Only means by what time the FIR has been lost? At 4 p.m.
Yes,
Incident has taken place 2:30 to 3.
No, another part I will come to, Milords. Now, FIR was lost by the time informant's husband arrived, other relations who are in close witness, all other persons arrived. So they may not, they are all there in the scene. I face an accident on the way. The pain remains, my mental disturbance remains, but after I call, 4 friends reach there to help me. It doesn't take away my pain. It doesn't take away my disturbance. But that the surrounding, that's what I'm saying. The surroundings makes me comfort. So that to present things in a proper manner.
He was saying that there is a coolness in preparing the FIR because the FIR has been lodged within a very close proximity of
1
the
hour.
time of incident.
1 hour.
And at the same time, you are also pointing out that there is some omission in it. In the FIR.
Because it's detailed.
So
that's why I'm saying.
You agree that it's a natural one, that the FIR is correct, which is.
No, I never intended that, Milords. It's not a natural one. Rather, it's an interference. That's why I say comfortably it's drafted. Still, then something is missing.
So what
means?
Yes.
Still, then it's missing.
All right. Anyway,
and the variations through inquest and other I pointed out. The variations that has been made and introducing eyewitnesses is something.
No, you are right. Once the court finds that the prosecution is trying to introduce eyewitnesses,
introducing eyewitnesses,
it is it's a really that point you are right. But what my brother is trying to point out is just imagine that
literally may not be literally.
Three members of my family have been brutally murdered.
Yes.
I have come to knowledge in my front two murders have taken place.
Milords, yes. I admit.
Such a state of mind, I am lodging the FIR.
Some part may be missing. But whatever the additions, if somebody is so disturbed, he may miss something. But can he add something to implicate another accused? Add to our witnesses? Add allegations? Add weapon of offense? Put a weapon on the hand of the other accused? Stable mind, all right. Stable mind missed it. It cannot be one way, Milords. How the stable mind planted it? Unstable mind, sorry. That's the question that comes to mind. One part, yes, it would have been okay. But the second part, adding eyewitnesses, putting a weapon, adding another accused, putting a weapon in his hand. Unstable mind cannot do all kinds of things unless he's in a comfortable position. In that sense, I have stated that.
The FIR is very natural. The FIR is very natural in this manner. Because what my learned
not concluded.
Just.
Friends,
it is
no issues.
has already got it. The state of mind. She must be in a state of mind must be in a daze and excitement.
Obviously, 3 members of his family has been brutally murdered.
In her front, she has seen 2 murders: murder of her mother and murder of her sister. And subsequently, she came to know about the murder of her brother-in-law. And then she is lodging the FIR within a short span of time.
1 hour.
And in the FIR, she has stated the name of both accused persons. The presence of both accused persons are there. And what role they have played, that she has described in the 161 sector, lateral. And subsequently in the court, she has deposed very clearly, which has been confronted to the IO, and I was already has gone through, and IO has categorically stated that she has stated. So PW1's version cannot be doubted at any stage. And because one thing is missing, because the way she has stated that yes, Hemanand restrained her sister to go to the rescue of her mother. So that part is missing in FIR,
That cannot be said because FR is not an encyclopedia of all the events.
No, Mr. Sadang is harping that let us say ये जो missing गुड़ाक हैला जो दीटा witness थिले बेली से ये कला से गुड़ाक it's all right state of mind अच्छी जाओ सेटा miss कला ये जो addition गुड़ाक को करूचंती जोड़ा कि आपण subsequent आपणर केस ही नुहे ताले addition जो गुड़ाक करूचंती जे सेही accused टा मध्य ଆଉ ଗୋଟେ weapon use କରିକିନା assault କଲା ଆପଣ ସେଇ point ରେ ଆପଣ
section 34 will be come into operation.
ଆପଣଙ୍କର ଏଇ ଯୋଉ କହୁନାହାନ୍ତି ଯେ ସେ ନବୀନ ର ସେ ଯୋଉ ତା ପୁଅଟା ମଧ୍ୟ ଟାଙ୍ଗିଆରେ ଯୋଉ ହାଣିଥିଲା
ମା ବି ବୋତଲ
ଏଇ ଯୋଉ ଆଡିସନ ଗୁଡାକ ଆପଣ ଆଣୁଛନ୍ତି ତ ଆପଣଙ୍କର prosecution intention from the beginning what was the intention that to implicate as many as accused of that family because of this land dispute or not that he is having.
Yes,
omission is all right omission ହେଇ ପାରେ ଯେ ସେ ଦିଟା ଆଇ ୱିଟନେସ୍ ମାନଙ୍କର ଥିଲେ ହୁଏତ ଏଇ ଟାଇପ ର ଷ୍ଟେଟ୍ ଅଫ ମାଇଣ୍ଡ ରେ ସିଏ ଘଣ୍ଟାଏ ଭିତରେ ତିନିଟା ମର୍ଡର ହେଇଛି ତାପରେ ସେ ଏଫଆଇଆର ଟା ଦଉଛି ସୋ ହୁଏତ ସିଏ ମିସ୍ କରି ଯାଉଥିବ ଏବଂ ଲ ଟା ଯୋଉ ସେଟଲ ଲ ଯେ ଏଫଆଇଆର ନଟ୍ ଏନସାଇକ୍ଲୋପିଡିଆ ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ବଟ୍ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ସିଏ add କରୁଛି ମାନେ ଏଫଆଇଆର right from the beginning which is not your case one after ତିନି ଜଣ accused କୁ ସେ trying to rope in.
And also you must have come through some judgments of the Supreme Court. Also there, in these type of situations, what happens usually, people of a family, I mean the members of family, they become more excited to get to implicate the accused persons in a more better way, so that they improve their statement in some way or other. That part you will also have to take care. If suppose PW3 and PW4 have stated not being present there, not having not seen the occurrence, if that stated something more, and that has been confronted to the IO.
No, that is why our rule would be to separate the chaff from the grain, right?
Yes.
But whether in a case of this nature, is it possible to separate or not? That is to be seen.
Yes.
It is that law is very settled. ଆମେ ସେପାରେଟ ଅଛି ଠିକ ଅଛି ଏଇ ପାର୍ଟ ଗୁଡାକ ବିଲିଭେବୁଲ ନୁହେଁ ଏଗୁଡାକ ପଶଛି ତାକୁ ଛାଡି ଦିଅ ଏତିକି ପାର୍ଟ ଟା ରିଲାଏବୁଲ ଏତିକି ପାର୍ଟ ତା ବେସିସ ରେ ୟାରି ରୋଲ ଆସୁଛି କିନ୍ତୁ ଏଇଟା ଏଇ କେସ ରେ ଏଇ ଯୋଉ ଇଏରେ ପସିବୁଲ କି ସିଏ କହୁଛନ୍ତି ଏଇଟା ପସିବୁଲ ନୁହେଁ କାରଣ ଯୋଉ ଟାଇପ ର ଆପଣ ପ୍ରଥମରୁ ଗୋଳେଇଛନ୍ତି କେସ ଟାକୁ ଯେ ତିନି ଜଣ ଆକ୍ୟୁଜ କୁ ଆଣିଛନ୍ତି ଜଣକୁ କହିଛନ୍ତି ମାରିବା ପାଇଁ ଆଉ ଜଣେ ଗୋଟେ ଲେଡି ଆକ୍ୟୁଜ ଟାକୁ ବୋଧେ ଇମ୍ପ୍ଲିକେଟ କରୁଛନ୍ତି ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଇନିସିଆଲି ଷ୍ଟେଜ ରେ ଆପଣ
they have not implicated the wrong persons because why even if they are the relations why they will go to implicate a person who is not no way involved in the crime.
No, that is the general proposition it all right yes, so this anything else you want to comment on this PW1 further?
No, it's accepting that.
So now
the other backgrounds will come.
No, that we will. You first finish up this
one. So far, one is concerned.
Okay, you finish first this 4 eyewitness.
Right.
One we have gone through. Now
then
you come to 3, then the
4,
other 4 and then 5. Okay.
3, 4 is relating to the second occurrence. 5 relating to the first occurrence.
Okay. No. So far as
3, 4 are common with this one.
So you come to PW3. Right.
Page 71.
Do we place it just now or after lunch?
Already 1 o'clock.
Okay. All right. After lunch.
Yeah. So one thing I'm being also can notice. After 2:30 minutes, I have some personal work. Of course, my learned friends are there. They'll take note of it. Plus,
we'll just today we'll just go through this PW3. If you have difficulty, we don't want that he should argue in your absence.
Yes,
because it's a death reference case. So we'll carry up to 2:30. It's all right. Then we'll take up tomorrow. There is no problem. All right.
Item 1,
Page 74. PW3. Sachin Sahu. Informant of this case is my Mausi. Deceased Sabitri Sahu is my mother. Deceased Pirovati Behera is my maternal grandmother. And deceased Giridhari Sahu is my mother. भूल लिखे है। I know the accused persons who are standing in the dock. The alleged incident was happened on 21/10/20.
Giridhari Sahu
ନାଇଁ ନାଇଁ ଭୁଲ ଲେଖା ଯାଏ ସେ ସାବିତ୍ରୀର
ମାନେ ବାପ ହବ ନା Giridhari Sahu is my father
ହଁ
mother is
correct. So the mother is father.
mother ସେ ଭୁଲ ହେଇଯାଇଛି।
yes
The alleged incident was happened on 21/10/20 around 3 p.m. On that day at morning, my father, my mother, and maternal grandmother had gone to our cultivable land. Around 12:30 p.m., they returned from the field. After taking lunch, my father again left to go to our land about 2:30 p.m. After a while, my mother and grandmother left the house. Following them, myself, my sister, and Mausi Manikya Hussain came outside. At a distance from our maternal uncle's house, there is a tube well. While my maternal grandmother was pumping the tube well, and my mother was collecting water in a bottle to take to the field, at that time, accused Nabin Dehuri and Hemananda Dehuri came to that place, and Nabin was holding a tangia. He dealt blows to my maternal grandmother. While my mother went to protest him, accused Hemananda Dehuri restrained her by dragging her hair, and accused Nabin also assaulted by my mother by means of tangia. The native village of my father is at village Kirimira. As my father was domesticated son-in-law, he was residing in my maternal uncle's house at village Lapada. The people of Lapada call my father as Kirimiria. Accused Nabin Dehuri was telling loudly that they have also killed Kirimiria. Out of fear, my Mausi took me and my sister to the house and closed the door. We raised hulla, hearing to which many villagers surrounded at the spot. We came outside and found both my mother and maternal grandmother were lying dead. Thereafter, information was given to the police. It was seen that my father was also lying dead in our cultivable land. Relating to our landed property, there was long-standing dispute between my maternal uncle's family and the family of the accused persons. Relating to this incident, I was examined by the police. I do not recollect the exact time when I was examined by the police, but I was examined by the police at our house on the very day of the occurrence. At the time while police examined me, nobody was with me. I do not recollect if I had not stated before the police that while my mother went to rescue my maternal grandmother, accused Hemananda dragged her hair and did not allow to go, and that out of fear, my Mausi took me and my sister inside the house. This has been confirmed by the IO.
which page point
135.
ଆଇଓ ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ particular ଟା contradiction ଟା
Para 4. Para 4 ଟା
ପାରା 4 ଟା କୋଉଠି prove ହେଇଛି ଆଇଓର evidence ଏଇ portion ଟା prove ହେଇଛି
ଆଜ୍ଞା
135
136 page 136 paragraph 30
paragraph para 13
30
evidence of PW IO Tara
20
PW 20
page 136. I am placing it. It is a fact that witness, namely Sachin Sahu, PW3, has not stated before me in his statement that while her mother went to rescue her maternal grandmother, the accused Hemananda dragged her air and did not allow her to proceed, and that out of fear her aunt.
Because this is the only overt act which has been attributed against Hemananda.
Yes, yes.
That has not been stated. It is
Yes.
made for the
It's a
first time.
subsequent development.
Okay.
Again.
Yes.
Para 5. I'm coming back to page 75. On the occurrence day, myself, my father, my mother, my younger sister, my maternal grandmother, my maternal great grandmother, my mausi, her 2 sons were in my maternal uncle's house at Lapada. The witness stated that this Mousa was present, but he left for his house at about 10 a.m. It is a fact that while my father left the house at about 2:30 p.m., all the above persons were inside the house. At the time while the accused persons attacked and assaulted my mother, maternal grandmother, myself, my sister, and my aunt were in our outside courtyard, and no other outsider was present at that time. While accused Nabin was assaulting my maternal grandmother, we had not raised any hulla. I cannot say how many tangia blows were given to my maternal grandmother by accused Nabin. 20 to 25 seconds after assault on my maternal grandmother, assault was given to my mother. If this is accepted, there is hardly any time to restrain or do anything else. I cannot say how many blows were given to my mother. While assault was given to my maternal grandmother, my mother was raising hulla that mo maaku maridala maridala. But I cannot say how many times mother told this. I know Kudhar is different from Budia. Accused Nabin was holding a Budia. I cannot say the size of the Budia. At that time, accused Nabin has wore a lungi and accused Hemando has wore a pant shirt. But I do not recollect if he had wore a half pant or a full pant. Hemananda had put on a green color shirt. I do not recollect what color of pant he had worn. I also cannot say the color of the lungi of which accused Nabin. My mother and maternal grandmother had wore sari, but I cannot say the color of their sari. Besides Hemananda, accused Nabin had another son who was died. Who was died prior to the alleged incident. These millers have some significance so far as the sentencing part is concerned. That's the last portion. I do not know how he died. It is not a fact that he was killed by our family members by administering poison. The only daughter of Nabin had got married. Now nobody is residing in the house of accused Nabin. His house is situated adjacent to the house of my maternal uncle. This is relevant. No assault was given by accused Hemananda. But the witness voluntarily states that he was assisting his father. Accused Hemananda was not armed with any weapon. Then it's not relevant. It is not a fact that my father, mother, maternal grandmother were murdered by the accused persons. It is not a fact that my father died during fighting of bullocks and as the horn of the bullocks pierced inside his body, and my mother and maternal grandmother died by coming into contact with harvesting machine, and due to long-standing enmity, we have created a false story and have false implicated the accused person.
What is your comments on this PW3, Mr. Sarangi?
We'll go to the other witness tomorrow.
Then
no, the comments are the mistakes are also this portion has both assaulted found to be false. As per this version also.
This man has not stated about both assaulting. It is stated by one.
The story combined effect.
If you compare it one, that's
and the development is also common. That he restrained by dragging the hair. This is a subsequent development proved through the IO. So this implicating the other accused all throughout has been found to be false.
No, the only role that has been attributed to
Restraint.
Nabin regarding restraint
Yes.
has never been stated before the police at the first in
Yes.
in the 161.
Yes.
That has been proved by you. And
In the FIR, it was not there. Developed in the 161 PW1. Then that same mistake, same development is also with PW3. So it's a consistent parrot-like mistakes.
he is very clear that he is not holding any weapon. He has
Weapon,
stated.
and this part is a development.
But how do you say that so far as his evidence relating to the main assailant, that is the father, has been in any way?
Again, I will go back, lords. The witnesses have been introduced.
Okay, that part you are.
So it's the mistakes are also common. The statements are parrot-like. I am not saying what they support or what is against me or for. Individually also, the mistakes or the developments are common. When means they are tutored, they are fixed, they are planted witnesses.
If we just consider the evidence of PW3 on the face of it, we will not consider the other aspect, then even if the
Nabin's assault is
that
part
it
remains.
is not there, but so far as the evidence relating to the that Nabin's assault,
that
is not being taken in the cross examination. If we consider the other things which you are
to that
pointing
extent,
out,
nothing is there.
In neither case, neither with PW1 nor with
no. If we consider the totality as you submitted, then that is a different thing. All right. Now you will go
if
to.
they are believed, then so far one is concerned, it will be a hard case. But for the other accused,
no, that is that we have seen also. Now you will go to which evidence?
Next PW4.
Fourth. That is that niece perhaps.
Again. Bhai Bon.
Sister of PW3.
S.K.Sahoo, page 77. Informant Manikya Pruseth is the younger sister of my mother. This is Pirovati Behra is my maternal grandmother. This is Savitri Sahu is my mother. This is Giridhari Sahu is my father. I know the accused persons who are standing in the dark. The alleged incident was happened on 21/10/2020. On the previous day, my Mausi, along with her two children and Mousa, had come to our house on the eve of Dasera. On 21/10/2020 morning, at about 10 a.m., my Mousa went away. At morning, my mother, father, and maternal grandmother had gone to our cultivable land. At about 12:30 p.m., they came to the house. After taking lunch at about 2:30 p.m., again my father went to our land. After a while of the departure of my father, my mother and maternal mother went. At a little distance from our house, there is a tube well. Let's hear that part, maybe copy or whatever, that my Mausi and myself, we came outside. Only that line is missing from PW3.
My mother and my
grandmother went. PW3 re se gote line thila je thereafter following them, my aunt and we came out. Eta seti koti jaichi. At a little distance from our house, there is a tube well. While my maternal grandmother was pumping the tube well, and my mother, she doesn't say she came out with the aunt or the that part is missing. There is a tube well. While my maternal grandmother was pumping the tube well, and my mother was pouring water in the bottle, accused Nabin Dehuri came and dealt a blow on the head of my maternal grandmother by means of a budia. My maternal grandmother fell down on the ground. Thereafter, he dealt 3 blows on her neck. While my mother went to rescue my maternal grandmother, accused Hemananda, alias Montu, restrained my mother by dragging her hair and accused Nabin assaulted by means of budia. Following my mother and grandmother, myself, my mausi, and my brother had came outside and had seen the incident standing near our door. While I was trying to proceed to my mother, my mausi restrained me and she took me and my brother inside the house and closed the door. We raised hulla. Hearing our hulla, some villagers came to the spot. After arrival of the villagers, we came outside. I took the mobile of one of the villagers and informed the incident to my Mousa, Udaya Chandra Pruseth, PW2. The villagers did not allow me to go near my mother and maternal grandmother. Both of the were lying dead there. Accused Nabin Dehuri was shouting and telling that he has killed Kimiria. Later on, we came to know that he has killed my father in our cultivable land. Relating to this incident, I was examined by the police. On the very day of occurrence, I was examined by the police, but I do not recollect the exact time and place where I was examined. At the time, while police asked me, many people were present there. They are Ranjan Barik, Ranjit Barik, Manas Naik, Adit Naik, Kanha Naik, and others. It is a fact that I had not stated before the police that accused Nabin dealt a blow on the head of my maternal grandmother, and while she fell down, he dealt 3 blows on her neck. And while I was trying to go to my mother, my mausi restrained me and took me and my mother inside the house and closed the door. And at the time of occurrence, my maternal grandmother was pumping the tube well and my mother was pouring water in bottle, and that I informed the incident to my Musa by taking the phone from a co-villager. It is a fact that I had stated before the police that while my father left the house, the door was half opened.
This part has been proved through the IO.
Yes.
You product
Page 136.
page 136.
Paragraph 31.
This line she clarified that. So confrontation was
paragraph 31. IO hela PW
20.
तापरे हाँ जोटा मानी गला जोटा सेटा आसंतु. It is a fact that I had stated.
Yes. It is a fact that I had stated before the police that while my father left the house, the door was half opened. It is a fact that I had stated before the police that while my mother and maternal grandmother went, as the door was opened, my mousie went to close the door, and I, along with my brother, followed her. It is not a fact that I had stated before the police that I, along with my brother, standing by the side of my aunt near our door through the half-open door, were seeing the incident. It is not a fact that I had not stated before the police that accused Montu dragged the hair of my mother. Besides, we three, my maternal grandmother.
So this was the previous statement. It has been proved, Mr. Katkia. जैसे जो फांका करिकिनी जो येटा से माने डोर टा देखिले से जो ये रे
but regarding restraining
एटा जो पचारजनी मो देखुनांदी. It is not a fact that I had stated before the police that I, along my brother, standing by the side of my aunt near our door through the half open door, we are seeing the incident. এই কথাটা সে কହୁଛନ୍ତି যে ଆପଣ ଏଇ କଥାଟା ପୋଲିସ ବାବୁଙ୍କ ପାଖରେ କହିଥିଲେ. ସେ କହୁଛି ନାଇଁ ମୁଁ କହି ନଥିଲି. Is whether it has been proved through the IO. କେତେ page ke
136
page 136
para 31.
That is a fact he is stating.
It is a fact that witness, namely Swapna Sahu.
अच्छा जदि एया हैला आपनकर केस जदि से साक्षीटा कहिला से पोजीशन टा केते माने से जो नळकू पाखरे जो येटा हैला ए जो आकर आंको घर कबाट फांकरे जदि देखिचंदी बोली कहउचंदी whether that place is visible, is it the case karan any question has been put in that way to the IO or no ye
IO ta podi doju 31
I'm just mind rakhi dantu je what is the distance between the house of this man, this PW?
Now this also affects the very question that they followed or accidentally they came or hearing the sound. So see whether they have seen from the beginning or whether in between or after?
ନାଇଁ ନାଇଁ ଆପଣଙ୍କର ଯୋଉ ଇଏଟା PW1 ର ଭର୍ସନ ଟା ତ ହଉଛି ପୁରା ପାଖାପାଖି ପଳେଇଥିଲା ମାନେ କାରଣ ସେ କହୁଛି ଡିଷ୍ଟାନ୍ସ ବି ମୁଁ ଏତିକି ଡିଷ୍ଟାନ୍ସ ରୁ ଦେଖିଲି।
No. They say outside. Baranda. Outside.
ଆଚ୍ଛା
ଘର ବାହାର
These
courtyard ରେ।
are also in this.
ନାଇଁ ନାଇଁ ମୁଁ is there any evidence that there is no visibility factor regarding
ନାଇଁ କ୍ୱେଶ୍ଚିନ୍ କରାହେଇଛି ଆଜ୍ଞା ସେମାନେ କହିଛନ୍ତି no it's visible.
visible ଆଚ୍ଛା ସେଇ ଜିନିଷ
ସଜେସନ ଖାଲି ଦିଆହେଇଛି
ହଁ ଆଉ ଖାଲି
ଯେ
ଦିଆହେଇଛି
ଜଗନ୍ନାଥ ମନ୍ଦିର ସେ ମନ୍ଦିରଟା ଅଛି from your house it's not to well is not ଖାଲି ସଜେସନ
ଖାଲି suggestion but it has not
no nobody has answered affirmative or
all right
31 136 page.
One fact has been proved that accused Hemananda is one to restrained by mother by dragging her hair and accused not been assaulted by means of Budia. That is consistent.
No,
That is very consistent.
that is the IO has said no. Para 31 or 136. It is a fact that witness, namely Swapna Sahu, PW4, has not specifically stated before me that the accused dealt 3 blows on the neck of the maternal grandfather and that while she was trying to go to her mother, her aunt restrained her and took not stated. She was trying to go to her mother, her aunt restrained her and took herself and her brother inside the house and closed the door, and that at the point of incident her maternal grandmother was pumping the tube well and her mother was pumping water in a bottle, and that he informed the incident to her uncle over phone, and that the door was half open, and that while her mother and maternal grandmother went to the door, her aunt went to close the door and she along with her brother followed her, and that she along with her brother standing by the side of her aunt near the door saw the incident through the half open door, and that accused Montu dragged the hair of her mother. It is so not stated.
Not stated.
Not specifically stated.
Not specifically stated.
Miller's evidence has to be conclusive.
No. So
See,
ନାଇଁ actually କଣ ହେଇଛି ମାନେ ଜଣା ପଡିଯିବ
ଏଇଟା ଯୋଉ ଏତେ ବଡ ହେଇଯାଇଛି ତାର ସବୁ ଅର୍ଥ ମାନେ
ନାଇଁ ସେଇ ଯୋଉ ରେକର୍ଡିଂ ରେ ଗଣ୍ଡଗୋଳ ହୁଏ ବେଳେ ବେଳେ ଏଇଟା ଟିକେ ବାହାର କଲେ ଯୋଉ କଣ ସ୍ୱପ୍ନା ସାହୁର ଟିକେ ଦେଖିଦବା
ଏତେ ବଡ ପାରାଟା ସେ ସବୁ ଯାକ ଗୋଟେ ପାରାରେ ଲେଖିଦେଲେ
ସେ ହୁଏ ସେମିତି ବେଳେ ବେଳେ ହୁଏ ତଥାପି 161 ଟା ସେ ସ୍ୱପ୍ନା ସାହୁ ସେ ଯୋଉ ଚୁଟି ଧରିକିନି ଅଟକେଇଲା ସେଇ ଜିନିଷଟା ଏଇଟା ବାହାର କରିକି ଦି ଜଣଙ୍କୁ ସାର୍ ମାନଙ୍କୁ ଦେଇ ଦିଅନ୍ତୁ ହଁ PW4 ହଁ ଦିଟା ପ୍ରିଣ୍ଟ ଏକାଥରେ କାଢି ଦିଅନ୍ତୁ
ଗୋଟେ ଦାଟରେ ସବୁ ହେଇଗଲା ମାନେ ଏଗୁଡା ସବୁ ଅଲଗା ଅଲଗା ଜିନିଷ ଏଇଟା ଗୋଟେ ପାର୍ଟ ଏଇଟା ଗୋଟେ ପାର୍ଟ ଏଇଟା ଗୋଟେ ପାର୍ଟ ଗୋଟେ ଦାଟରେ 4ଟା ରହିଗଲା ଫାର୍ଷ୍ଟ ପାର୍ଟ ରହିଗଲା ସେକେଣ୍ଡ ପାର୍ଟ ରହିଗଲା ମାରିଆଟା
ସେଟା କଣ କଣ୍ଟ୍ରାଡିକ୍ସନ ଯେତେବେଳେ ପଚରା ଯାଏ ସେତେବେଳେ ବି ଟ୍ରାଏଲ ଜଜଙ୍କର ଦେଖିବା ଦାୟିତ୍ୱ ଚେକ୍ କରିବା ଦାୟିତ୍ୱ ମଧ୍ୟ ଆଙ୍କର ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ତାହେଲେ ଆଉ ସେ ବିଶେଷ ଭୁଲ ହବନି ଯାହା ପଚାରିଲେ ସେତେବେଳେ ରେକର୍ଡିଂ ଯୋଉ କରିଦିଅନ୍ତି ଏଇ ତମେ ଏଇଟା କହିନ ସେଇଟା କହିନ ତାପରେ ସେତେବେଳେ ଆଇଓ ଆସିଲା ବେଳକୁ ସେଇ ମେକାନିକାଲି ବେଳେ ବେଳେ ଯୋଉଗୁଡାକ କହିଥାଏ ବି ସେ ତା ଦେହରେ ପଶିଯାଏ so that this is usually
maybe like the PW3 she said bracketed that though volunteers that she assisted though denied that dragging maybe some kind of thing.
Please Mr. Sarangi
ମୁଁ ସ୍ୱପ୍ନା ସାହୁ ବୟସ
14
ବର୍ଷ ମୃତ ଗିରିଧାରୀ ସାହୁ ଥାନା ସୁଆଂଶୁ ଆଜି ଆପଣଙ୍କୁ ଦେବା ମୋର ମୌଖିକ ଏଇକି ବୟାନ ହେଇକି ଯେ ମୁଁ ନବମ ଶ୍ରେଣୀର ଜରାଗୋମା ହାଇସ୍କୁଲରେ ପାଠ ପଢୁଅଛି ମୋର ଆଈ ମାର ପୁଅ ନଥିବାରୁ ମୋ ବାପା ପୁଅ କରିକି ଆଣି ରଖିଛନ୍ତି ମୋର ବାପାର ନିଜ ଘର କିରିମିରିଏ ଅଟେ ଆମ ଘରେ ମୁଁ ମୋର ଭାଇ ମୋର ମା ବାପା ଆଈ ଓ ବୁଢୀମା ରହୁଥିଲୁ ଆମ ପଡୋଶୀ ନବୀନ ଦେହୁରୀଙ୍କ ଘର ସହ ଆମର ଭଲ ସମ୍ପର୍କ ନାହିଁ ଆମ ଘର ଲୋକ ତାଙ୍କ ସହ କଥା ହେବାକୁ ମନା କରିଥିଲେ ଦଶହରା ପାଇଁ ମୋ ବାପା ମୋର ଆଣ୍ଟି ଘରକୁ ଡାକି ଯାଇଥିଲା ଓ ଗତ 16-10-20 ଦିନ ମୋର ଆଣ୍ଟିର 2 ପୁଅ ବିବେକ ଜିଲେଶ
ଦୀପକ ଓ ଦିନେଶକୁ ବୋଧେ
ଦିନେଶ ମୋର ବାପା ଧରି ଆସିଥିଲା। ତାର 20/10/20 ଦିନ ମୋର ମୁନୁ ବାପା ମଉସା ମତେ ଆଣିଲେ ନା କଣ ଆଣି ସନ୍ଧ୍ୟା ବେଳକୁ
ପହଞ୍ଚିଲେ
ରାତିରେ ସବୁ ହସ ଖୁସିରେ ଖାଇ ପିଇ ଶୋଇଲୁ। ସକାଳେ ମୋର ବାପା ମା ଆଈ
ଏଇଠୁ ଇମ୍ପୋର୍ଟାଣ୍ଟ
ପିରୌତି ବେହେରା ମିଶି
8:30ରେ ଜମି ଧାନ କାଟି
ଧରି 8:30 ବେଳେ ଜମିକୁ ଗଲେ। ପରେ 12:30ରେ ମୋ ମା ବାପା ଆଈ ଘରକୁ ଫେରିଲେ। ଆସି ଭାତ ତୁଣ ରାନ୍ଧିଥିଲେ। ସବେ ମିଶି ଖାଇକି ବସିଲୁ। ମୋର ବାପା ଖାଇକି ଶୋଇଲେ। ମୋର ମା ଆଈ ମିଶି କଥାବାର୍ତ୍ତା ହୋଇ ଟିଭି ଦେଖୁଥିଲେ। ମୁଁ ଟିକେ ଶୋଇ ପଡିଥିଲି। ପରେ ବାପା ମାଳକୁ ଯିବାକୁ ବାହାରିବାରୁ ମୁଁ ଉଠିଲି। ଦୀପକ ଓ ଦିନେଶ ଶୋଇଥିଲେ। ମୋର ଦଦା ସଚିନ ବି ପାଖ ବଖରାକୁ ଆସିଲା। ମୋର ବାପା 2:30 ବେଳକୁ ମାଳକୁ ଆଗେ ଗଲେ। ପରେ ମୋ ମା ଓ ଆଈ
ଟିଭି ଦେଖୁଥିଲେ
ଆଣ୍ଟି ସଙ୍ଗେ କଥା ଲାଉ ଟିଭି ଦେଖୁଥିଲେ ଓ 3ଟା ହେବ ମୁଁ ଘରୁ ବାହାରିଥିଲି। ମୁଁ ଓ ମୋର ଦାଦା ଆସି
ଆଣ୍ଟି ପାଖରେ ଥିଲେ।
ଖାଇ ଯିବାର କିଛି ସମୟ ପରେ ମୋ ଆଣ୍ଟି କବାଟ ଦେବାକୁ ଉଠି ଗଲେ। ପଛେ ପଛେ ମୁଁ ମୋର ଦାଦା ବି ଗଲୁ। ମୋର ଆଣ୍ଟି କବାଟକୁ ଅଧା ଖୋଲି କରି ରଖିବାରୁ ସେ ଫାଙ୍କା ଆଡୁ ମୋର ମାଉସୀ ପଛରେ ରହି ମୁଁ ଓ ମୋର ଦାଦା ଦେଖିଲୁ ଯେ ଆମ ଆଈ ପିରବତୀ ବେହେରା ଯାତ୍ରା ମଣ୍ଡପ ନଳକୂପ ପାଖେ ପାଣି ପାରୁଥିବା ଜାଗାରେ ଥିଲା ଓ ଆମ ଗ୍ରାମର ପଡୋଶୀ ନବୀନ ଦେହୁରୀ ତାକୁ ଟାଙ୍ଗିଆରେ ହାଣୁଥିଲା। ସେଠି ପିଣ୍ଟୁ ଦେହୁରୀ ପାଖେ ଠିଆ ହୋଇଥିଲା। ପରେ ମୋ ମା ନଳକୂଅ ପାଖକୁ ଦୌଡୁଥିଲା। ନବୀନ ଦେହୁରୀ ମୋ ମାର ପଛେ ପଛେ ଗୋଡାଇ ମାର ଦାଣ୍ଡରେ ତାକୁ ଟାଙ୍ଗିଆରେ ଚୋଟ ଉପରେ ଚୋଟ ମାରି ଚାଲିଥିଲା। ମୋର ମା ତଳେ ପଡି ଚିତ୍କାର କରୁଥିଲା। ମୋ ମା ଦୌଡୁଥିବା ବେଳେ ମଣ୍ଟୁ ଦେହୁରୀ ମୋ ମା କେ ଛେକିଦେଲା। ହେଲେ ମୋ ମା ଭାଗି ପାରିଲା ନାହିଁ। ଏସବୁ ଦେଖି ମୋର ଆଣ୍ଟି ଡରେ କବାଟ ଖାପିଦେଲା। ନବୀନ ଦେହୁରୀ ମୋର ମା କେ ହାଣିଥିବା ଟାଙ୍ଗିଆ ଧରି ଆମ ଘର ରାସ୍ତାରେ ତା ଘରକୁ ଗଲା। ଗଲାବେଳେ କହିଗଲା କିନ ମାରିବାକୁ ହାଣି ଦେଇଛି।
ସେ ମଣ୍ଟୁ ଯିଏ ସେ ହଉଛି ସେଇ ଯୋଉ ହୃଦାନନ୍ଦ।
ଆଜ୍ଞା। ଆସିଲେ ମୋର ମା ସାହୁଥିବା ପଡୋଶୀ ବେହେରା ରକ୍ତ ଜୁଡୁ ବୁଡୁଇ ଦଣ୍ଡରେ ନଳକୂପ ପାଖରେ ମଡି ପଡିଥିଲେ। ଗାଁ ଲୋକ ମିଶି ବାପା ଖୋଜିବାରୁ ମୋର ବାପା ଗାଁ ବିଲମାଳେ ରକ୍ତ ଜୁଡୁ ବୁଡୁ ହୋଇ ମରି ପଡିଥିଲେ।
ଜିନିଷ ପ୍ରାୟ ରହିଛି ମାନେ ଏଭିଡେନ୍ସ ଏଇ ଯୋଉ ନବୀନ ଦେହୁରୀ ନାଁରେ ଏଇ ଯୋଉ ଟାଙ୍ଗିଆ ମାରିବା ବୋଥ ଦିଏ ଏଇଟା ରିଷ୍ଟ୍ରେନ୍ ଏଇ ଯୋଉ ଛେକି ଦେଲାଟା ହଉଛି ସେଇ ରିଷ୍ଟ୍ରେନ୍ ତ ଆଉ ଛେକି ଦେଲା ମାନେ ରିଷ୍ଟ୍ରେନ୍
ଚୁଟି ଧରିବା ପାର୍ଟଟା ନାହିଁ ମାନେ ଯୋଉ ଚୁଟି
ଛେକି ଦେଲା ମାନେ କଣ
ଅଟକେଇଦବା ଆଉ ଅଟକେଇଦବା
ହଁ ମାନେ କୋଉ ବାଟରେ ରେଷ୍ଟ୍ରେନ୍ କରିଛି ସେଇଟା ନାହିଁ କିନ୍ତୁ
ଚୁଟି ଧରିକି ଟାଣିଦେଲା ପରଟା ଆସିଛି
ମାନେ ଛେକିଦେଲା ମାନେ
ଛେକିଦେଲା ସେଟା ଅଟକେଇଦବା ଜଣକୁ ଗୋଟେ ଡିରେକ୍ସନ ଯିବାର।
ବଟ୍ ମାନେ ହ୍ୱାଟ ୟୁ ସେ ଦ୍ୟାଟ୍ ଇଟ୍ ଇଜ ନଟ୍ ଦେୟାର ଦ୍ୟାଟ୍ ଯୋଉ
that's why they
ଚୁଟି
said specifically not there here that is specifically not there but ଛେକିଦେଲା କଥାଟା ଅଛି।
ଓକେ ପ୍ରୋସିଡ୍ ସେ ଯୋଉ ତାଙ୍କର ଇଏଟା ଆପଣଙ୍କର ଟାଇମ ହେଇଗଲାଣି କି? ଇଟ୍ସ ନଟ୍ ଆଚ୍ଛା କୋଉ ଯାଏଁ ପ୍ଲେସ୍ କଲେ ଆପଣ?
ଏଇଟା ଖାଲି ଆଉ 2ଟା ପାରା ପଢି ଦଉଛି। ଆଜ୍ଞା
ଏତିକି ଛାଡି ଦିଅନ୍ତୁ 2 ମିନିଟ୍ ଲାଗିବ।
ପାରା 5 besides we the three my maternal grandmother Dinesh and Deepak the two sons of Mausi were in the house on that day. All total 4 blows were given to my maternal grandmother by accused Nabin. All blows were given to her neck. Soon after assault on my maternal grandmother, my mother was assaulted. First assault was given on the head of my mother, but I cannot say the specific place on the head on which the assault was given. All total 6 budia blows were given to my mother. 3 blows were given on her head. 1 blow was given on her neck. 1 blow was given on her cheek, and 1 blow was given on her hand. I cannot specifically say on which portion of the neck assault was given, so also in which part of the hand assault was given. Assault was given to my mother on the village road. Nearby the occurrence spot, there were the houses of Susila Chaudhary and Tikeshwara Naik. It is a fact that adjacent to the house of accused Nabin, there is my maternal uncle's house. It is not a fact that adjacent to our house, there is the house of Rameshwar Chaudhary, Binod Naik, Santosh Kumar Patel, and Anu Chaudhary. It is not a fact that adjacent to the tube well, the road which leads to the village Amlikhaman to village Jorabago. The length of that budia was about 1.5 feet, and its iron portion was about 6 inches, but I cannot say what was the width of the sharp side. I cannot say if any of the person was present at the time of the assault on my mother and maternal grandmother. The witness states that he had not seen anybody. At the time of occurrence, accused Nabin had wore a lungi and accused Hemananda was wore a pant and a green color shirt. I cannot say the color of the pant. I also cannot say the color of the lungi of accused Nabin. Remaining inside the house, we raised the hulla, and while we were outside, none of us had raised any hulla. It is a fact that prior to the alleged occurrence, there was land dispute among the family of the accused persons and my maternal uncle. While we came outside after the arrival of villagers, I saw the villagers, namely so-and-so, so-and-so, so-and-so. I cannot say at what time police reached at the spot. At the time of occurrence, my mother had wore a pink color sari, but I do not recollect the color of the sari to which my maternal grandmother had worn. It is not a fact that my father, mother, and maternal grandmother were not murdered by the accused persons. It is not a fact that my father died during fighting of bullocks, and as the horn of the bullocks pierced inside his body, and my mother and maternal grandmother died by coming into contact with harvesting machine, and due to long-standing enmity, we had created a false story and have falsely implicated the accused persons. In this case, and in order to support our case, I am deposing falsehood. Accused Hemananda was not armed with any weapon. It is a fact that no assault was given by accused Hemananda. He had only restrained my mother.
They made it specific, like PW3.
এই যে লাইনটা কোয়া হচ্ছে, this witness whether he has stated about the assault on the mother of on her mother, this witness PW4 by Nabin.
Yes.
এটা দেখিলে
All blows are given to her neck.
ନବୀନ ପ୍ରଥମେ ତ ସେ କହୁଛି
Grandmother.
ତା ପୂର୍ବ ଲାଇନଟାକୁ ପଳେଇ ଆସନ୍ତୁ, ଯା ପୂର୍ବ ପେଜ 77 ର Nabin came, dealt blow on the maternal grandmother, ঠিক ଅଛି, by means of budia. Maternal grandmother fell down. Thereafter, he dealt 3 blows, say maternal grandmother, right? While my mother went to the rescue, my maternal grandmother, accused Hemananda restrained my mother by dragging her hair. ଅଟକେଇ ଦେଲା. Accused Nabin assaulted by means of budia, ମାନେ to whom?
The mother that
mother ସାବିତ୍ରୀ କି ଦି ଜଣ ବସି ଆସଲ କରିଥିଲେ.
ସେଇ ଜିନିଷଟା ନାହିଁ ତ ମୁଁ ମିଟ୍ କରୁଛି ତ ମୁଁ ସେଇଥିପାଇଁ କହିଲି ଯେ ସେ ଯୋଉ ନବୀନଟା assaulted by means of budia to my mother ବୋଲି
ମଦର ହେଇଥିଲା.
ହଁ, କାରଣ ଏଇ ଯୋଉ ଷ୍ଟୋରିଟା ଯଦି ଏଇଟା ସେଇଆ ହୁଏ, ତାମାନେ ଆପଣଙ୍କର ଦେଖନ୍ତୁ, ଯଦି ଏଇ ଲାଇନଟା ଆସେ, ତାମାନେ ସିଏ ମାକୁ ଧରିଥିଲା ବେଳେ ଜଣେ ଆକ୍ୟୁଜ୍ଡ ମାର ଚୁଟି ଧରିଛି, ଆର ଆକ୍ୟୁଜ୍ଡଟା ତା ମାକୁ ମାରୁଛି. ଦ୍ୟାଟ୍ସ ଏ ମୋର ସିରିୟସ୍ ଆଲିଗେସନ ହେଲା. ସେଥିପାଇଁ ମୁଁ କହୁଛି ଯେ ଏଇ ପର୍ଟିକୁଲାର ଲାଇନଟାକୁ ଟିକେ କାଲି ଆମେ ଦେଖିବା. ଏଇ ପର୍ଟିକୁଲାର ଲାଇନ ଉପରେ, ଏଇ ଲାଇନଟାକୁ ମିଷ୍ଟର ଷଡ଼ଙ୍ଗୀ ଚିନ୍ତା କରନ୍ତୁ. ଇଏ ଧରିଲା, ସେଇ ଧରିଥିବା ଅବସ୍ଥାରେ ସିଏ ତା ମାକୁ ମାରିଲା. ଖାଲି ଯଦି ହେଇଥାନ୍ତା ଯେ ମାନେ ମାଡ ହଉଛି, ଇଏ ଯାଉଛି ସେଭ୍ କରିବାକୁ, ତାପରେ ଅଟକେଇ ଦେଲା, ଅଟକେଇ ଦେଇ ଛାଡିଦେଲା, ଅଲଗା କଥା.
But this part they have contradicted.
ଧରିଥିବା ଜଣେ ଧରିଲା ଆଉ ଜଣେ ତାକୁ ମାରିଲା ସେ ପୋଜିସନ ଟା ଯଦି ଆସିବ that is at a different altogether
Even obstruction part, there is a answer. Two dead bodies. The first old lady's dead body was near the tube well, but the daughter's dead body was on the road, some distance. So, if there any obstruction at all by this other accused, then hardly there are any scope for that.
we are on the facilitate ଆପଣଙ୍କର restraint ଯୋଗୁ ଯଦି facilitate କରୁଛି ଅନ୍ୟ accused କୁ ମାରିବାକୁ
ସେଇଟା ହିଁ କହୁଛି ସେଇଟା ହିଁ କହୁଛି ଯେ restraint part ଟା though it's a diluted
ତିନି ଜଣଙ୍କର evidence ରେ ଏଇ particular aspect ଟା ଟିକେ ଦେଖନ୍ତୁ
no ତିନି ଜଣଙ୍କର subsequent development ଗୋଟେ fixed that by pulling the hair restraint
ନାଇଁ ଅନ୍ୟମାନେ କଣ କହିଛନ୍ତି ସେ ପୁଲିଂ ଇଏ ଯାହା କହୁଛି ପୁଲିଂ ହେୟାର କରୁଥିବା ଅବସ୍ଥାରେ ମାଡଟା ହଉଛି
ନାଇଁ ସେଇଟା ସ୍ପେସିଫିକାଲି ଅନ୍ୟମାନେ କହିନାହାନ୍ତି
ମୁଁ ସେଇଆ କହୁଛି ସେଇଟା ଦେଖିବା
ସେଇଟା ନାହିଁ but pulling the hair, this is a subsequent development in all three. That is the same. So she said obstructed. This fellow somehow obstructed from fleeing away or anything. Now, if the other statement is when the old lady was assaulted.
ପଢିଲେ ଆମେ ଯୋଉ 161 ସେ ଛେକିଦେଲା ମାନେ ଅଟକେଇଦେଲା that's a different matter. But ଜଣଙ୍କର ଚୁଟି ଧରିଥିବ
yes, I got it.
ତାକୁ facilitate କରି ସେଇଟା that is different.
That is
that is freedom one's personal.
No.
ଦେଖିବା କାଲି ଦେଖିବା ଆପଣ ଇଏ
simultaneously record no
one trust.
I have authorized commit meeting.
No, it's all right. We'll continue tomorrow.